Good morning, everyone. Welcome. My name is Annette Johns, and I'm the Deputy Registrar with the Newfoundland and Labrador College of Social Workers. Happy Social Work Month to everyone attending our webinar this morning. As you may have heard, the theme for Social Work Month 2025 is Social Work is Everywhere. And that theme certainly promotes awareness of the diverse areas of practice in which social workers are employed. And it also recognizes the knowledge, skills, and expertise that social workers bring to these diverse areas of practice in enhancing the health and well-being of individuals, families, groups, and communities. In celebration of Social Work Month, I'm very happy to be the moderator for today's education event, along with my colleague, Wendy Skinner. Hi, Wendy,
Good
who,
morning,
uh,
everyone.
who is the Provincial Professional Practice Consultant for Social Work with Newfoundland and Labrador Health Services. And this webinar is a collaboration between NLCSW and NLHS. The focus of today's webinar is on social work documentation. It's a topic that we continue to receive requests for continuing professional education on, and we have over 460 registered for this event today. So that certainly speaks to the interest in this particular topic. And we are therefore very delighted to have Dr. Frederick Reamer joining us today to present on this very important topic. We do have 5 hours scheduled for this event, and we'll be taking some mini breaks in the morning and afternoon, and a lunch break as well. During the breaks, you're free to stay on the webinar platform while you step away for your lunch or break, and we'll give times for when the presentation will resume following these scheduled breaks. Please note that should anything happen, and we all know things can happen, power outages or whatnot, if we happen to lose connections, the presenter or us happen to lose any connections, we will endeavor to get back on the platform. So if that should happen, try to get back in as well. We have 5 hours, so anything could potentially happen. Once the presentation starts, we do encourage you to type in any questions that you might have for Dr. Reamer regarding social work documentation using the question mark widget to the left of your screen. Only the moderators and presenter will see those questions that are posted in the Q&A, and we'll review those questions when we get to that period during the presentation. So that's our housekeeping items. Now that they're out of the way, I do have the privilege of introducing our speaker for today's webinar, Dr. Frederick Reamer. You can certainly read Dr. Reamer's full bio on the webinar platform, but I would like to make a few introductory remarks. Dr. Reamer has been on the faculty of the School of Social Work, Rhode Island College, since 1983. He's teaching and research focused on professional ethics, criminal justice, mental health, healthcare, and public policy. Dr. Reamer chaired the national task force that wrote the Code of Ethics adopted by the National Association of Social Workers and served on the Code Revision Task Force. Dr. Reamer also chaired the national task force sponsored by the National Association of Social Workers, the Association of Social Work Boards, and the Council on Social Work Education and Clinical Social Work Association that developed standards governing social workers' use of technology in professional practice. And I actually had the honor of working with Dr. Reamer on the ASWB International Task Force for Technology Use in Social Work Practice. Dr. Reamer has lectured nationally and internationally on social work and professional ethics. His books, which include a lot, do include Risk Management in the Behavioral Health Professions, a practical guide to preventing malpractice and licensing board complaints, the Social Work Ethics Casebook, Ethical Standards in Social Work, and Boundary Issues and Dual Relationships in Human Services, just to name a few. I have my shelf with lots of Dr. Reamer's books, so I encourage you to read those as well. In 2016, Dr. Reamer was named Social Work Pioneer by the National Association of Social Workers for his commitment and dedication to the social work profession and the improvement of social and human conditions at the local, state, and national and international levels. And certainly Dr. Reamer's mark on the social work profession and ethics is certainly something that I'm delighted to have him join us here for this Social Work Month celebration. So, Dr. Reamer, I'm beyond delighted that you're joining us here today. We're all really looking forward to your presentation, and I'm now going to turn the virtual podium over to you to begin.
Thank you, and thank you for the very kind introduction. And I just want to say that I appreciate Annette's work and Wendy's work to make this happen. So much effort is required behind the scenes, and I truly appreciate it. I'm not just being polite. I truly, truly appreciate it. So I believe in being very candid. This is my experience. Social workers sign up, register for events like this with varying degrees of enthusiasm, particularly when the topic is documentation in social work. Perhaps some of you got up this morning, you looked at your schedule, you saw 5 hours on documentation in social work. You need to listen to some guy from the United States, Rhode Island in particular, talk about these issues, and you pumped your fist in the air and you thought, what a way to spend a day. I could not be more excited. Others of you, perhaps, looked at your schedule, you saw 5 hours on this topic, and you thought, geez, the clock can't tick fast enough. This is going to be about as exciting as watching paint dry or parking meters expire or grass grow, or maybe the snow melt in northern Canada in March. Like, it takes a long time. There may be people who are here today because you're required to be here, because maybe you have encountered some problems associated with documentation and somebody has encouraged you or required you to take this webinar. Whatever your reasons are for being here, whether you are here with wild enthusiasm or perhaps some reluctance, I hope by the time we log off today, we log off today, which will be 3 p.m. your time, we're in different time zones, I hope you have the following thought. Oh my goodness. Oh my goodness, is this stuff complicated? So before I dive into the material, I want to share one anecdote with you. I spend an enormous amount of my time in the United States. I've done it a couple of times in Canada, but mostly in the United States, raising this hand. And I'm required to do that as I solemnly swear to tell the truth, the whole truth, and nothing but the truth. And I am sworn in as what the courts call an expert witness. That's not my term, that's the court's term. As an expert witness in two kinds of matters. First, instances when social workers are named as defendants in lawsuits, alleging negligence, alleging malpractice. Those cases, and I've been involved in hundreds of them, typically involve allegations that social workers neglected to, for example, assess a client's suicidal risk properly, didn't develop a suicide risk management plan, breached confidential information without proper authorization, did not skillfully manage boundary issues and dual relationship issues and conflict of interest issues, did not terminate services appropriately, abandoned a client, and on and on and on. And in these cases, the attorneys for the plaintiffs, the party bringing the suit, will, I would say 100% of the time, subpoena social workers' records. And they will review every single word, every single syllable. If there are handwritten doodles on the side of paper records, they'll look at them. If there are scribbles on Post-it notes, they will look at them. If there are electronic records, they will scrutinize them. And their goal is to find problems with documentation. And when I go into a courtroom, and sometimes I am there having been brought in by the plaintiff's attorney, and sometimes I'm there having been brought in by defense attorney. I don't specialize. When I walk into a courtroom or I walk into a deposition, as you may know, is what's called the discovery phase of the case, sworn testimony, the discovery phase of the case before trial, if there is a trial. When I go into a courtroom, when I go into a deposition hearing room, I fully expect the social worker's records to be displayed on a screen, a large LED screen. When I started my career years ago, We had like overhead projectors. Some of you were old enough to remember those with transparencies. We don't have those anymore. We have large LED screens. The lawyers, and I'm referring, of course, to the United States, where, to be frank, there is much more litigation. I'm not happy about that, but there's much more litigation in the US involving social workers than there is in Canada. But you have your share. The lawyers will use very fancy software that they have installed on their laptops, which will be in the courtroom, in the licensing board hearing room. They will project the social worker's notes on the screen, if it's a courthouse, for the judge, the jury to see. And the lawyers will cherry pick portions of the documentation. If it's on the plaintiff's side, the lawyers will cherry pick documentation, display the words, the sentences, the phrases, the paragraphs on that screen. And there's only one reason plaintiff's attorneys do that. Only one reason. And that is because they have found documentation problems. They have found significant documentation problems, and they're going to use them in their efforts to undermine the defendant social worker. In contrast, every coin I know has two sides. If it's defense counsel will review every element of a social worker's documentation, everything. And they're going to be looking for elements of that documentation that they can use to defend the social worker against the allegations. And if the defense lawyer's screen shows social worker's notes, documents, correspondence, and will be called ESI, electronically stored information, which, by the way, when I started my career, didn't exist. But now we have electronically stored information recognized in law, including relevant text messages, relevant email messages, relevant online social networking posts, electronic health and medical records. That will be displayed on the screen for one reason. And that's because defense counsel believes the documentation supports the defense of the social worker. So documentation, in my experience, and this is not hyperbole, the quality of social workers' documentation, in my experience, typically determines the outcome of litigation. No exaggeration. High quality documentation, entered in a timely fashion, carefully proofread, edited carefully, can save the day, can save a social worker's career. Poorly documented encounters with clients, sloppily written notes that were not proofread carefully, disaster, unmitigated disaster displayed on the screen for everybody to see. And that's not hyperbole. The same thing goes with the second type of case in which I am sworn in as an expert witness. And those are licensing board cases. In the United States, as you may know, every state, whether it's Maryland or Missouri or Mississippi or Montana, every state has its own licensing board, including the District of Columbia. In some states in the US, there's a separate social work board. In some states, the legislature has decided to combine behavioral health, human service professions. So in some states, we have not an isolated social work board, but a board that includes social work, mental health counseling, marriage and family therapy, and so forth. I get involved in lots of licensing board cases where a disgruntled client, usually by then a former client, files a board complaint, which is easy to do. Simply go to the website, identify the social worker, click on a tab that says file a complaint, and free type. You don't need a lawyer, you don't need to pay any fees. And then the social worker gets a letter that obligates the social worker to respond, depending on the state, usually in 21 days or so, with their version of what happened in response to the former client's allegations. Again, usually related to things like alleged unauthorized breach of confidential and private information, failure to obtain proper informed consent, mismanagement of boundary issues in dual relationships and conflicts of interest, allegations of abandonment, and so forth. And in those cases, in licensing board proceedings, here too, I see it over and over and over again. The quality of social workers' documentation typically determines the outcome. This topic is not fun for most people. It can be rather dry and tedious. I get it. And oh my goodness, is it important? So let's go to the PowerPoint. And Annette or Wendy, please break in if you're not seeing what I hope you're seeing. What I hope you're seeing, everyone, are the objectives. There are 4 of them for today's training. First, I want to highlight the critical, and I emphasize that word critical, importance of documentation in behavioral health broadly, social work in particular. Second, I want to explore complex documentation decisions, the hard decisions. I imagine many of you over the years have had to decide on occasion, given who might have access to your records down the road, should I be vague in this note or should I be detailed in this note? If I'm detailed in this note and third parties access the records, will that harm my client? Should I be vague? Or are there instances when vagueness in notes is not a virtue, it's a disaster? And I've seen both. I think both can be true. That vagueness in notes, depending upon who might have access to those notes, possibly for adversarial purposes, for example, in a child custody dispute, which I see very frequently, where the attorney for one parent subpoenas the social worker's notes and wants to see if there's anything in there that can be used against the other parent in their vitriolic, tense custody battle. Vagueness sometimes is a virtue. But I've also seen instances where social workers decided to be vague in notes, and in my judgment, they should not have been vague in that note. So these are complex documentation decisions. Those of you who provide services to minors may have encountered instances when a parent or a legal guardian wants access to your notes. They want to know what's going on in their child's life. I understand that. I'm a parent. If my kid was struggling, I might want to know what the kid is talking about with the therapist, even though I ideally should respect the privacy of that relationship. And suppose the parent or legal guardian asks for a copy of your records. They want to know what's in there. Now, I'm no expert on Canadian law, obviously, and I'm not a lawyer, can't give you legal advice. But I'll tell you how it works in the US. In the US, I tell every social worker, if you're providing services to a minor, assume the parent or legal guardian has the legal right to see your notes. There's some narrow exceptions, which I can get into. But generally speaking, in the US, parents and legal guardians have a right to see a social worker's notes pertaining to the minor child. And that, of course, often influences what social workers decide to include in their notes, right? Suppose your client is a suspect in a police investigation. Your client is a suspect in an armed robbery investigation, a sexual assault, child molestation investigation, and a detective finds out, perhaps from a family member of the client, that you've been providing counseling. And the detective wants to talk to you about what you know. And they want to see your records. Well, these are complex documentation decisions, not only about when to be vague, when not to be vague in notes, who should have access to the notes, but criminal case investigations. What are the rules around disclosure? The third bullet point, today's objectives. I want to talk about what I think are state-of-the-art documentation standards, and I think they have evolved, right? They've changed in my experience. Now, I'm no expert on what social work education programs in Canada have been teaching But I've had opportunities many times over the years to confer with social work educators in Canada. And my sense is what has been taught in Canadian social work education programs is, in most respects, pretty similar to what I find in the United States. I remember years ago, and those of you who've been a social worker for a long time perhaps heard an instructor, a professor, at some point say, well, when you're documenting, you got to protect your client's privacy, so less is more. Less is more. Keep your notes short, keep them vague. I've heard that advice for many years. My opinion, it's bad advice. I think it's really bad advice based on what I've seen. My advice is it depends. I think sometimes the shorter note is the better note. I think sometimes the longer note is the better note. It depends on the facts, depends on the circumstances. I think sometimes the vague note is the better note. And I think sometimes the vague note is a disaster. It depends. So I think this is much more nuanced than we have led social workers to believe over the course of the profession's history. So my third objective for today is to talk about what I think are state-of-the-art documentation standards. And by the way, obviously, you can tell I'm going to share my opinions with you. That's why I'm here. I don't assume you'll agree with everything I say. You might disagree, and that's fine. I absolutely believe in the free exchange of ideas. I do. I'm an educator. I value free speech. So if you have an opinion that's different from mine, please feel free to share it in the Q&A or the chat, and we'll talk about it. No problem. The fourth thing I want to do today is to identify the ways in which I think quality documentation protects clients, first and foremost, that's our obligation, of course, and enhances risk management, by which I mean protecting social workers as well as clients, preventing litigation as best we can, preventing licensing board complaints, regulatory body complaints as best we can. Right? Sometimes we can't prevent these things. But if lawsuits get filed, if licensing board, regulatory board complaints get filed, high quality documentation, in my experience, goes a long, long, long way toward protecting that social worker. So those are the four objectives. And I'm going to try to keep you awake today. Again, I recognize that in theory, this could be a really dry topic, but I'm going to do my best. As Annette said, we will take a 15-minute break in the morning, 15-minute break in the afternoon. We're going to break for lunch for 45 minutes, and we'll let you know when we're ready to do that. Okay. So forgive me for sounding a bit academic here, but I'm a professor, so that's like what we do. I got to give you some overview material here. So I'm probably telling you what you already know. In my opinion, documentation in social work serves 6 different roles. Many of you are caseworkers, counselors, you have clinical roles, so clearly documentation is used to assess. As we say, the biopsychosocial assessment, the intake assessments, critically important. I get involved in litigation and licensing board cases, regulatory body cases, where it appears the documentation of the assessment falls short of what should be in there. The social worker swears under oath that she, he, or they asked questions about suicide risk, homicidal ideation, but it's not documented adequately. The suicide risk management plan, the social worker swears was detailed, comprehensive, but it's not documented properly. Planning and delivering services. Clearly, documentation is vital to sound, comprehensive treatment plans, casework plans. Third, documentation is used for accountability purposes. We all know that social workers are accountable to multiple parties, clients who typically have a right to see their records. In the US, a couple of years ago, Congress enacted a law, a very strict law, that mandates that social workers make any electronic records they have on behalf of clients available to clients immediately, without delay, without interference. It's a strict federal law. So we're accountable to clients with regard to documentation. We're accountable to funders, insurers, other agencies who may also serve our clients and may have a need to see our records. Right? Courts of law, right? Lawyers, judges can subpoena records, order their disclosure. In the US, health insurers have lots of utilization review protocols. I'm less familiar with them in Canada, and they often have access to records. Fourth, documentation is critically important to enhance continuity and coordination of services. I imagine many of you have referred clients to other providers, and you may have a duty to share your documents with those other providers, often contingent on client consent. Some of you are supervisors, the fifth tile there. Some of you are supervisors. I get involved in lots of litigation and licensing board, regulatory board cases where supervisors are also placed under the proverbial microscope. Questions surface with regard to the quality of supervision. Did the supervisor meet with the social worker as required by policy? Was it 1 hour a week, as the agency policy says? What did they talk about? Did they talk about how the Toronto Blue Jays are going to do this year? Or did they talk about what they're supposed to talk about in social work supervision? Is there any evidence of a boundary violation between supervisor and supervisee? Are they dating as well as meeting for supervision purposes? Supervisors' notes are often subpoenaed. In the US, we have a concept called vicarious liability. There's a Latin phrase for it, respondeat superior, R-E-S-P-O-N-D-E-A-T, and then the word superior, like superior. And under the law in the US, and it may be the same in Canada, a supervisor can be found liable if there's evidence that the supervision was flawed, was negligent. Why am I bringing this up with regard to documentation? Because I often see supervisors' notes that, in my opinion, sometimes are not sufficiently detailed. They're not, supervision is not documented regularly or comprehensively. Supervision notes are critical. For those of you who are supervisors, I would ask you whether you have supervision agreements. That's a document. Today's topic is documentation. My opinion is every supervisor and every supervisee, whether this is for licensure purposes or a social work student who's being supervised in a practicum or an internship, my opinion is there ought to be a supervision agreement, a document that spells out the nature of the supervision, what the supervisee can expect, what the supervisor expects, including, with regard to ethics, a section that says explicitly, again, my opinion, that the supervisee is expected to bring to the supervisor's attention any questions or concerns about ethical issues such as confidentiality exceptions, management of complex boundary and dual relationship issues, decisions about termination, decisions about documentation, that ought to be included in a supervision agreement. It helps to clarify for the supervisee what the expectations are, but it also protects a supervisor in the event that, and I've certainly seen this happen, in the event that a supervisee does not bring to the supervisor's attention, issues that should have been brought to the supervisor's attention. And had they been brought to the supervisor's attention, perhaps the problem could have been prevented. Having those details in a supervision agreement protects the supervisor. And finally, we know that documentation is often used for evaluative purposes. Some of you evaluate clinical services, counseling services. Some of you have responsibilities for program evaluation. and the quality of documentation there is also critically important. I think you folks may find this really interesting. I don't want to dwell on history, but I think this is fascinating. So, in the late 1800s, about when social work as a profession was getting started in the Western Hemisphere, there was a conference, the Conference of Boards of Public Charities. And on this slide, you will see word for word, this is not a paraphrase, this is word for word, documentation guidelines that were taught to the early social workers in attendance. They were taught to document, and this is, for clinical purposes. Quote, the kinds of mental and moral perversion, unquote, in clients' lives. Quote, descriptions of morbid and debasing conditions of the mind. Quote, points at which neglect of social and moral duties began. Quote, information regarding the totally idiotic or weak-minded in 3 generations living and dead. Quote, total inebriates in 3 generations living and dead. Quote, the client's capacity for self-support without the direction and control of a superior authority or constant advice and supervision. I trust you agree with me. Thank goodness documentation standards have changed. They certainly have. Not only with regard to what you see here on this slide, but also with regard to the point I made a little while ago, that the adage, which was very common for years, when you document social worker, less is more, vague is better, I think is no longer true. I think we have a much richer, more nuanced understanding. So today, I'm going to focus on 4 core documentation issues, which I think are complicated. There's room for debate here, room for difference of opinion, and I suggest there are 4 questions we ought to ask. When social workers document, what content should they be including in their notes? Should it be vague? Should it be explicit? Should it be detailed? Lots of judgment calls. Second, what kind of language and terminology should social workers use? What do I mean by that? Well, we have a lot of jargon in social work. We certainly do in the US, and I trust you would find a lot of jargon in Canada as well. I review lots of documents, progress notes, clinical notes, treatment plans, and some of them contain jargon that I don't understand. Jargon that a typical jury would not understand. Jargon that a judge may not understand. It's what we sometimes call psychobabble. My preference is plain English. Keep it simple, keep it straightforward, keep it understandable. We have choices to make about what kind of language and terminology to use. And I have seen instances where, in my opinion, the language a social worker chose to use in her or his or their documentation turned out to be very problematic. And that's language that was displayed on the screen in the courtroom or in the licensing board hearing room. Third, credibility. What steps can social workers take to enhance the credibility of their documentation? Now, what kinds of things can undermine credibility? To me, this is not hypothetical. I have experienced what I'm about to say. I have been in the courtroom. I've been in the licensing board hearing room when the social worker's notes, email messages, text messages, excerpts from online social networking posts are displayed on the screen. And the lawyer who put them up there is adversarial. In other words, this is the plaintiff's attorney, not the defense attorney. It's the prosecutor for the licensing board. And that lawyer who's trying to undermine the social worker's credibility points out errors, points out misstatements of fact, points out dates that are wrong, points out patterns of grammar problems, spelling problems, punctuation problems, which alter the meaning. You know, in my role as a professor for decades, and I do mean decades, I would review students' papers, right? They turn them in for course assignments. I read them like professors typically read papers. And I'm focused mostly on the content, of course, the substance. That's the most important aspect of a student's work. And I always provide feedback on grammar and punctuation and spelling. And I say to my graduate students, you know, I'm not here to teach English. I'm not here to teach writing. That's not my job. That's the job of folks in the English department. But as a social work educator, I know that if your documentation is filled with a pattern of spelling problems and punctuation problems and grammar problems, that's likely to be used against you. Not only could it harm your client because of the lack of clarity, but it could be used against you. If ever you're named as a defendant in a litigation case or a respondent, that's the noun we use in licensing board cases, in a licensing board complaint. Lawyers point this stuff out. They want to make it look like you're not well educated. You don't write carefully. Look at that slop, I heard a lawyer once say. And fourth, the fourth core documentation issue, who should have access to your records, under what circumstances? The parent of your client who's a minor, law enforcement officials, lawyers who are adversarial, do they have access to your records, and under what circumstances? So those are the four themes I want to focus on today. In my experience, there are three patterns associated with ethical risks related to documentation. When I think about the hundreds and hundreds and hundreds of cases on which I've been privileged to consult, I've noticed three patterns with regard to documentation, which I think pose an ethical risk. First, mistakes. These are good social workers, well-educated social workers, dedicated, earnest, and sometimes they make mistakes. We can all make mistakes. I've made mistakes. It was a long day. I saw 12 clients. I confused the third client with the eighth client. They have similar names. I documented details in the client's record that are associated with the other client. I saw in the morning, oops, that was a mistake. And it's an electronic record, and that note is locked. That was a mistake. Or I consulted with Dr. Smith, the psychiatrist, about my client's apparent suicidal ideation, but I forgot to document that I consulted with Dr. Smith. That became very important when my client attempted to die by suicide, and I got sued, the social worker says, for failure, alleged failure, to prevent a suicide attempt. And I know I spoke to Dr. Smith, but I forgot to document it. Now, you know, in my career, I spend a lot of time with lawyers, and I have for decades. And in the US, and I apologize for that common refrain in the US, but I want to, acknowledge that what goes on in the US may be somewhat different from what goes on in Canada in some respects. In US law schools, here's what law school students are typically taught, and I've heard this hundreds of times. Quote, if it's not written, it did not happen. Unquote. If it's not written, it did not happen. Unquote. Now, I know that's not true. I suspect you know that's not true. The social worker may have spoken to psychiatrist Smith. It happened. It wasn't documented. That doesn't mean it didn't happen. But lawyers love that mantra because in a litigation or licensing board, regulatory body proceeding, if a social worker says, I did have that conversation, I did conduct that assessment, I just neglected to document it, the comeback from the lawyer on the other side of the case is likely to be, well, in our business, if it's not written, it didn't happen. And it's an uphill climb. Who needs the uphill climb? Now, maybe there are other ways to verify that the social worker did consult with psychiatrist Smith. If psychiatrist Smith still works in Eastern Canada and hasn't moved to British Columbia, maybe Dr. Smith is available to testify. But I've seen instances where Dr. Smith isn't available to testify. It's an uphill climb. So mistakes, wrong dates. We call these errors and omissions. Errors, facts that are in a note that are not true. Oops. And omissions, details that should have been in the note that's not in there. Omissions. Electronic records, in my experience, have led to all kinds of documentation problems. And by the way, I'm a fan of electronic records. I know they can be annoying. The software can be challenging. I get all that. I think they're more secure than the typical paper records. I've been in agencies where there are paper records in the file cabinet, and the third drawer is off the tracks and can't be shoved in because it's damaged and nobody can find the key that was lost 3 years ago. Those records are not secure. I think electronic records typically are more secure. But I've also seen mistakes, the first theme here, with electronic records, where social workers see a client repeatedly, week after week after week. The issues are pretty much the same. The discussions are very repetitive. And to save time, the social worker copies and pastes a note from last week into this week's record of the session. And almost all of it's accurate. The copy and paste is accurate. But in the fourth sentence of that paragraph, there's a statement of fact that was true last week, but it's not true this week. And the social worker didn't proofread the pasted note carefully and edit it. And now there's an error in there. And a smart attorney on the other side of the case, the adversarial side of the case, and this actually happened in a case involving a lawsuit alleging that a social worker failed to properly assess suicide risk and come up with a reasonable and competent suicide prevention plan. The lawyer put that note up on the screen, the pasted note, knowing there was an error, waited until the social worker was sworn in and under oath, and had that social worker admit that she made an error. She copied and pasted. And that's a disaster. That's a disaster. In a little while, I'm going to talk about the increasing use among social workers of artificial intelligence platforms that are designed to record clinical notes, progress notes. The AI software, you may be familiar with this, is actually quite good. There are multiple platforms out there, multiple platforms that social workers can use that, with a client's permission, will process a recording of a clinical or casework encounter. There's no human being reviewing the recording. AI, artificial intelligence software, is reviewing the recording and generating the note. And I've read lots of those notes. And I would say most of them are really quite good, but they're not perfect. And I've seen instances where the note generated by the artificial intelligence platform misconstrued a portion of the conversation, left out a critically important detail. Here's an example. Those of you who provide clinical or counseling services, have you worked with a client who has a traumatic memory in the middle of a session, begins to cry as the client recalls the assault? The client's crying. You're a clinical social worker. You typically would document in your note that the client began to cry when the subject of the traumatic memory came up. Well, tell me, how does the artificial intelligence platform hear the tears? It can't. It's not going to be in the note. because there may not have been any conversation about it. I mean, the social worker might have said, I notice you're crying. Tell me about that. And maybe it'll be reflected in the note. But sometimes tears come down clients' cheeks and a social worker may not say anything, in which case the AI software will not detect that. I was involved in a case where a client who's in recovery, doing a lot of hard work and doing really well after years of drug addiction, in a counseling session, the client disclosed to the social worker confidentially, air quotes, confidentially, that 7 years earlier, that client, when he was in the throes of his heroin addiction, he was selling heroin to support himself and his own drug addiction. The client disclosed to the social worker, as he is processing the trauma of his life, that he committed a murder. He got into a dispute, he said, with one of his heroin customers. The guy, according to the client, ripped him off, ran away without paying the client. And the client says to the social worker, I panicked, I carried a gun, I was dealing heroin, a lot of heroin dealers carry guns, and I fired shots in the air to scare this guy. You got to pay me. And the client, 7 years later, is describing this incident. And the client says to the social worker, I actually fired shots in his direction, and I was running, and he was running, and I had bad aim, and I hit him, and I killed him, and I ran, and I got away with it. I've never been charged, never been indicted, never been tried, never been sentenced, nothing. And why is the client telling the social worker this? Because the client says he feels horribly guilty. He feels remorse. He says, the guy didn't deserve to die. I feel awful. Thank goodness I'm doing so much better now. But I have to tell you, the client says, I have a lot of guilt. I have to deal with it. Well, the note generated by the AI software included content related to the murder reported by the client. It's in the note. It's in the note. My opinion, and if you want to disagree with me, that's fine. My opinion, that note should not reference the murder, because I know there are dozens of ways, literally dozens of ways in which that note could be subpoenaed, ordered disclosed by a judge. And if that note ends up being disclosed and the police find out about that murder, that note could be used to prosecute the client. Now, I'm not minimizing the seriousness of a murder, of course not. But this is a client who is doing well. And I would argue that our duty as a social worker is to support that client's efforts to wrestle with his guilt, his remorse. And if I were writing that note, forget artificial intelligence, if I were writing that note, the note would say, client disclosed details about a past traumatic event, shared feelings of guilt and remorse. We processed ways to deal with those feelings, or something like that. Because what I've learned in my career is that a social worker who's documenting that kind of conversation should be thinking like the most talented chess player on planet Earth. The most talented chess players, in my experience, are really good at what they do because they are able to think 4 or 5 moves ahead. That is what makes them so good and better than the sort of, I'm just fooling around chess player. They have this remarkable brain power and ability. If I make this move and Annette makes that move, then I might make this move, but Annette might make that move. And I am processing in my brain as a chess player all the permutations and combinations, which will influence my decision about my next move. I would argue that that's how we ought to think about documentation as a social worker. If I include this detail in this note today, I've got to think several moves ahead. Who might have access to this note down the road? For what purposes? Might they be adversarial in nature? And that will influence my decision about whether to be vague or detailed. So back to the example involving the client who disclosed that he committed a murder. In my opinion, thinking like a chess player, my note would be vague because I have to anticipate the possibility, even if it's not the probability, but the possibility that that note will end up being subpoenaed, ordered disclosed by a judge for some reason. For example, if the client ends up being involved in a child custody dispute, I've seen this happen many times, my note would be vague. But the artificial intelligence platform doesn't understand that. It doesn't understand that. The details about the murder will be in there, and it's up to the social worker to proofread the AI generated note carefully, edit it as needed. And here's what I'm finding. That this relatively new AI technology is leading to mistakes. The first tile on this slide. Some social workers are drawn to this AI software for documentation purposes. They're drawn to it because it saves time. I get that. I understand that for many people, documentation is tedious, it's time consuming, perhaps uncompensated. And so having this AI tool to generate that note very quickly and rather accurately is terrific. It's the shiny new toy. But I'm now encountering instances when social workers are making mistakes if they don't carefully proofread, carefully edit the AI generated note. That leads to the second theme, ethical risk, the green tile. These are not mistakes. These are deliberate judgments, deliberate decisions about what to document and how to document. To repeat briefly, should I be vague in this note? Should I be detailed in this note? Should I release my notes to the parent of my client who's a minor? I've got lots of judgments to make here. What if the detective shows up from the RCMP? They want to know what I know. What do I do? And third, the purple tile, ethical misconduct. And sadly, I've encountered instances, too many instances, of fraudulent documentation. Social workers, well educated, who document fraudulently. Do I think it's pervasive? I do not. I do not want to exaggerate. I actually think it's relatively rare. I think the vast majority of social workers are honorable people who serve with integrity. I really do believe that. And because of the work that I do, I have encountered social workers who, sadly, documented counseling sessions that never happened, ever. Fraud to generate revenue. I've encountered social workers whose clients died and there was a fatality investigation. And the social worker went back into the record after the client's death and altered the record, documenting services that never happened as part of a cover-up. Too many instances of fraudulent documentation. Some of you may have heard the word amphiboly, not a well-known word. And if you haven't heard it, let me tell you what it means. Amphiboly, great word, has to do with ambiguity in speech and documentation, today's topic. Ambiguity in speech and, for our purposes today, in documentation. When there's uncertainty about what the writer meant, there's uncertainty about the grammatical construction. And I have seen disasters because of amphiboly in social workers' notes and records. Now, here are a few kind of humorous examples that I've taken from a wonderful book, which I'll tell you about a bit more later, called Eats, Shoots, and Leaves by the author Lynn Truss. Look at the first one. Let's eat, comma, grandma versus let's eat grandma. Now, the words are exactly the same. There's no difference. The only difference is a comma after the word eat. Let's eat, comma, grandma. In other words, it's time to eat. Hey, come on, grandma, come to the table. But if you leave out the comma, guess what they're having for that meal? They're going to eat grandma. That's not a good idea. I trust we would all agree. That's amphiboly. right? If you don't put that comma in there, the meaning is quite nefarious. The second example, her parents watered the flowers, comma, yet they died. Please tell me, the word they, does it refer to the parents who died or the flowers that died? I would prefer the flowers, but it's not clear, amphibole. Third example, if you take the motor out of the car, comma, I will sell it to you cheap. Well, the word it, does it refer to the motor, the engine, or does it refer to the car? Amphibole. It's important to be clear. Similar to the grandma example, let's eat kids versus let's eat, comma, kids. We don't want to eat children. Bad idea, right? Red tape holds up new bridge. We hope not literally, right? It's an expression. And how about this one, the last one? A woman, comma, without her man, comma, is nothing. Well, that's really insulting. Like, a woman needs a man? Please. A woman, comma, without her man, comma, is nothing. As opposed to a phrase that is exactly the same wording, but different punctuation. A woman, colon, without her, comma, man is nothing. The words are exactly the same, but you change the punctuation just a little bit and the meaning changes dramatically. And I've seen that in social work records. So let's take a look at a few actual examples. Sue has not been depressed for more than 3 weeks. Sue has not been depressed for more than 3 weeks. Well, tell me what that means in a clinical note. Does that mean when Sue has been depressed, she's never been depressed for more than 3 weeks at a time? Or does it mean she has not been depressed during the past 3 weeks? I don't know. Amphibole. The second example, the client reported that he will not use drugs when he has custody of his child. What does that mean? If he obtains custody of his child, there's a custody dispute, then he says, I'm not using drugs anymore. The end, I'm done. Or does it mean only when his kid is with him will he not use drugs? That's really different. If dad, for example, has this weekend with the kid, he's not going to use drugs. And then he transferred the kid back to mom. Does that mean he's going to start using again? Amphibole. Both parents tried to take care of the children, comma, but they were hospitalized. Well, who was hospitalized in that note? These are actual notes. Were the parents hospitalized? Were their children hospitalized? I don't know. So here are some case examples really quickly. Okay. Documentation matters. Right. Again, 3 patterns, mistakes and inadvertent errors, examples of judgment about documentation and misconduct. This is a screenshot from the licensing board in the state of Maine. And most of my examples, not surprisingly, are coming from the US. So bear with me here. This is a screenshot, the website for the licensing board in the state of Maine. You can look up, because it's public information, a case in which I testified as an expert witness. A case where a social worker, very dedicated, was providing services to a high-risk adolescent who was having all kinds of troubles. And the adolescent failed to show up for several appointments in a row. The social worker, deeply caring, was very concerned about that and left voicemail messages, sent text messages. The kid doesn't respond, this 17-year-old. And the social worker knew that the adolescent loves Facebook, is like tethered to Facebook. And so the social worker got creative and logged onto Facebook at various times, day, evening, to see if this adolescent client is logged onto Facebook to try to connect with her that way. Multiple attempts, nothing. But eventually, the social worker one evening late into the evening, connects with the adolescent on Facebook. I don't know if you've gotten my messages. I've been trying to reach you. I'm worried about you. You've missed a couple of appointments. And the adolescent responds, and they have more than an hour exchange on Facebook where the kid discloses what's going on, why she hasn't been in touch, and it's deeply troubling. And it's a clinical session on Facebook. There's no question about it. I have a copy. I have the documentation. I have a printout of that entire exchange. The kid fell asleep. Dad, who worked second shift, came home, went to shut down his daughter's laptop, but he was a dad and he was curious and he's worried about his kid. He knows the kid's in counseling having some issues, and Dad poked around her Facebook site. I'm not defending Dad's decision to do that. I'm a father. I would like to think I wouldn't do that unless I was deeply concerned about my kid's well-being. But Dad poked around and he learned, reviewing that entire exchange on Facebook, about high-risk behavior his daughter's involved in, lots of challenges she's facing that he knew nothing about until he read all that. And Dad went into orbit. He was angry that a social worker would have, in effect, a counseling session with his daughter on Facebook. Dad filed the licensing board complaint, and I testified in this case. That documentation, the late evening, nighttime clinical session on Facebook, that documentation was entered into evidence. The board subpoenaed the social worker's handwritten notes. I have copies of them. They're scribbled. A lot of them I couldn't understand, which was a problem. Legibility. And I'm not kidding. When I flipped over some of the handwritten notes, on the other side are drawings, are, I don't know, as Canadians, whether you follow college basketball in the US, but what we call March Madness this time of year, there are these brackets, and I'm seeing these brackets on the back side of the social worker's notes. It's like this, the optics are terrible. That social worker no longer has a license to practice. Documentation did him in. I thought the board was too draconian. I thought he could learn from this experience, but they thought otherwise. This is a case from Illinois, a case in which I testified. It's a very sad case where social workers and others provided services to the mother who delivered a newborn who tested positive for substances. The child was placed in foster care. The mom was so eager to parent this child. She wanted to address her trauma. She wanted to address her mental health challenges, her substance use challenges. She was a dedicated client, and the court and protective services authorized delivery of services to her with the goal of enabling her to parent this child. Long story short, social workers and others worked with this mother for 15 months. While the child's in foster care, they had supervised visits for bonding purposes. And after 15 months, the social workers and others recommended to the court, to the protective service officials, that the child be placed with mom, that she had made so much progress. Everybody approved. The child was placed with mom at about this time of year, March. And then there's April, May, June, July. This now 18-month-old is dead, allegedly murdered by mom. It's a horrible case. The surviving family members sued everybody, alleging negligence that the social workers and others never should have recommended placement of the child with the mother. I was the principal expert witness, public information. I had to review all the documentation in this case, a mountain of documentation. I was very confident, despite the very sad outcome, I was confident that I could defend the social workers and others. I think they exercised reasonable judgment. My testimony was that sometimes in social work and in behavioral health, there are very sad outcomes. And those sad outcomes are not necessarily the result of negligence. They're sad outcomes. Despite our best efforts, sometimes things don't work out well. I was very comfortable defending the social worker's judgment, but I could not defend documentation errors. And there were significant documentation errors, particularly related to the problem of what we call auto-population with electronic records, where there was a date that was wrong, auto-populated, which nobody caught, and it was a disaster. Documentation errors have consequences, and they sure did in this case. Look at that headline. The jury came back with a $45 million verdict. $45 million verdict. Documentation errors have consequences. I'm not going to cover every one of these slides because we don't have the time, and we do need to take a break in about 10 minutes. But I'll be very brief here. This is an excerpt from a New York Times article. About the difficulty that many adolescents have accessing counseling services, waiting lists, things like that. And it features an adolescent. And in the New York Times article is an excerpt from her psychiatrist's record. If you were to read this article, you will see an actual excerpt from the psychiatrist's notes regarding the adolescent, medication, treatment. Now, how did that get into the New York Times article? A client has a right to the record, typically. A client can decide to share the clinicians, the social workers, the psychiatrist's notes with a reporter, who then has the right to include those details in an article for the public to see. The point being, a social worker, a psychiatrist, psychologist, we have no control over that. If a client has access to the records, client decides to share them with the reporter, then our notes end up on page 1, so to speak, or whatever page it is. We have to think about that when we document, like the chess player. Collaterals. How many of you in your social work role occasionally meet with collaterals? To use the jargon, the client's friend, the client's relative, the client's parent, the client's adult son, daughter, whatever. Well, this is a screenshot of an article I wrote for a social work journal on the use of collaterals in social work, ethical and risk management issues. And I wrote this article because of a case in which I was an expert witness where a social worker included a collateral, which is a fine thing to do. During a session that included a collateral, the collateral shared information about the collateral's life with the social worker that's relevant to the care of the client. The social worker documented some of those details shared by the collateral. I understand why. The records ended up being subpoenaed as part of a child custody case, which meant that the very sensitive information the collateral shared with the social worker ended up being disclosed to third parties. The collateral was extraordinarily upset about that. I didn't give you permission, social worker, to share those details. I thought that was confidential. And the collateral filed the licensing board complaint. I was brought in as the expert witness, and I asked the social worker, when you brought the collateral in, did you explain to the collateral how confidentiality works? That the collateral is not your client. Your ability to protect any information shared by a collateral is limited under law. Did you explain that? You use what we call a collateral agreement, which some social workers use, not all, that spells all this out. They have a collateral sign it. Documentation. Did you document that you told the collateral this? Did you document in a collateral agreement how this works so the collateral would fully understand what's protected, what's not protected? And the answer was no. There's no documentation of any of this. And it was a problem, a big problem in this case, which is why I wrote that article. This is a case in Wyoming in which I served as an expert witness, again, public information. A case where social workers and others were indicted in federal criminal court. In the US, you can be indicted in state court, Wyoming, or federal court. They were indicted in federal court. And these practitioners were charged with fraud. The federal prosecutor alleged that the social workers and others were billing the government for casework and counseling services in violation of the law. They called it fraud. I was the expert witness. My job was to review documentation, today's topic, a mountain of documentation. And it was my opinion that there was no evidence of fraud, that the prosecutor misunderstood the nature of social work services, casework services. And I think the documentation saved them. The high quality documentation saved them. Look at the headline. The jury came back after a multi-day trial and acquitted them. They could have gone to prison had the jury come back with a guilty verdict. I absolutely believe, in the attorneys, the defense attorneys absolutely believe, the careful documentation is what saved them. This is a case from South Dakota in the US where a woman, a client, sued a substance use disorder treatment program, alleging that a staff person shared documentation that, under the law in the US, what we call Title 42 CFR Part 2, which of course doesn't apply to Canada, that a staff person disclosed documentation to law enforcement officials without authorization. Lawsuit. Documentation decisions have consequences. We all know, sadly, there have been school shootings, more in the US than in Canada. And one of them took place in Michigan, close to the Canadian border, Oxford, Michigan. An adolescent who was interviewed by two counseling staff at the school because staff were concerned about this kid. They interviewed him, brought his parents in. The parents allegedly minimized their concerns, left. They ended up being charged and convicted. They're in prison now. And this kid was allowed to go back to the classroom. The counselors allowed him to go back to the classroom. They didn't look in his backpack. He had a weapon, goes into a bathroom, pulls the weapon out, goes into the classroom, and starts spraying bullets. And he kills and injures people. I was called within hours by a Washington Post reporter. And that's this article that you see here. After Michigan school shooting, experts question what could have prevented it. And the reporter talked to me for nearly 2 hours about all the ethical issues around confidentiality and protection of third parties. But the conversation then turned to today's topic, documentation. And we talked about questions that are likely to surface about the quality of the school counselor's documentation. Documentation of their interview with this kid, documentation of their rationale for not disclosing concerns to law enforcement, for not calling protective services when the parents left the building, the rationale for allowing this kid to go back to the classroom, and on and on and on. At the end of the conversation, the reporter asked me whether I thought the school counselors would be sued. And I said, I'm not a soothsayer. I don't have a crystal ball. But based on my experience, I think there's a very good chance they will be sued, and the documentation will be key to those lawsuits. They've been sued. Documentation matters. The paper trail, digital trail matters. This is a New Hampshire case involving a dispute between parents about whether the dad should have a right to the social worker's records pertaining to the children who are clients. This case goes to the Supreme Court in the state of New Hampshire. Decisions about documents have consequences. I'm going to skip some of this because we just don't have the time. There's a lot of debate in the US about whether it's appropriate for social workers to conduct online searches for information about clients without clients' knowledge or consent. Annette mentioned that I was chair of the task force in the US that wrote the Social Work Code of Ethics, adopted by the National Association of Social Workers. We now actually have a standard in the code regarding the ethics of conducting online searches without clients' knowledge or consent. I frequently tell my students, my graduate students, if you decide to conduct an online search, the Code of Ethics requires you to document your rationale, the reason for the online search, right? mere curiosity isn't sufficient. There's a documentation issue there. This is a Massachusetts case in which I served as an expert witness. A very prominent behavioral health organization was charged with fraud by the Attorney General's office in Massachusetts, alleging that social workers and others billed for services provided by unlicensed, unsupervised social workers and others in violation of the law. I was the expert witness for the Attorney General's office, and it's a documentation case. I had to review literally thousands of clinical records, supervision records, and render my opinion under oath about whether there was evidence of fraud. We'll look at that headline. That behavioral health organization that provided services to mostly low-income clients had to pay $25 million to settle this matter over alleged false and fraudulent claims. And it's the documentation that led to that outcome, $25 million. This is a Pennsylvania case in the US where a social worker was sentenced to prison because she falsified her records. After the death of this child, there was a fatality investigation. The social worker was indicted, charged with fraud, and sent to prison. She became a prison inmate in our federal system because she falsified records. The social worker. There are case after case after case of problematic documentation. This is a Michigan case in which I served as an expert witness, where a social worker, I'm embarrassed to say, who worked in a trauma-informed care program, was indicted in criminal court, sex with multiple clients, all of whom had trauma histories. I had to interview them as part of my expert witness work. Well, in this case, we found documentation, a digital footprint, which demonstrated conclusively that this social worker was involved sexually with his clients. A digital footprint, email messages, things like text messages, right, which leave a digital footprint. And he was sentenced to serve up to 10 years in prison. We have cases in the US involving fraud, and documentation proved the fraud. Case after case after case after case after case. So I'd like to now ask you some questions, get the results of these polls, and then we'll share the results with you, and then we'll take a break. So, Annette, may I invite you, please, to share the poll questions?
Yes, certainly. So here's the first polling question. I don't know, Dr. Reamer, if you wanted to introduce the poll and
No, please, if you don't mind, they're probably ready to hear another voice. So please go ahead.
Okay, perfect. So this question is looking at just get a sense of where you work primarily. So if you could just take a few seconds to indicate. There's a whole range of options there, and of course other, because there's so many options, as we know from the theme for Social Work Month, the diversity of the profession, so we can't capture everything in the poll. So if it's other, do indicate that as well. So we'll just give you a few seconds to do that. Okay, seeing the results come in there, just give a couple more seconds. Okay, I just pushed the results to the audience there. So what we're seeing is about 5% or so of people who are attending work in addictions, 28% in mental health psychiatric, 16 services to seniors, about 10% in medical services, 8% physical disabilities, We have about 7% in child protection, very few in adoptions and housing, victim services, private practice about 3%. So and then we have other 11%. So the majority would be in terms of addictions, mental health, medical services, services to seniors, child protection, and physical developmental disability services. Will I go to the next poll?
Please do.
Okay. So the next polling question is, are you currently using an electronic health or medical record to document services? So the options are yes, no, both paper and electronic. So we'll just give you a few moments to note there if you're using only electronic or not, or if you're using paper and both. Okay, we'll just give you a few more seconds to indicate your choice, because we know that there is sometimes a slight delay there in terms of the slides moving. Just want to give everyone an opportunity to okay, a couple more seconds. All right. So I'm just going to push that out to the audience. So we have, yes, so we had pretty much 60% noted that they are using an electronic health or medical record to document service. About 11% said no, and about 30% said paper and electronic record. So thank you. Okay, next polling question. And Dr. Reamer, when you want me to stop and if you want to provide any comments, you can just let me know there.
That's fine. No, please just keep going. That's great.
Okay. Perfect. Okay, our next polling question is, how familiar are you with the Personal Health Information Act? So that's the Provincial Health Information Act. So we just want to see how familiar you are with that. If you're very familiar, somewhat familiar, or not familiar, just indicate your choice there. Of course, it's anonymous there. We don't see who's responding. We just get numbers. So feel free to complete that and add your choice there. Again, giving you a little bit of time because of that delay. But I see lots of responses coming in, so I'll just give you a few more seconds to indicate your choice or your option there. Okay. All right. So we had about 26% who indicated they were very familiar, about 63% who noted that they were somewhat familiar, and almost 12% who were not familiar. So thank you for that. And we do have a few more polling questions, so I'll just move on to our next polling question. The next question, excuse me, is how familiar are you with the Access to Information and Protection of Privacy Act, ATIPA? So again, the options are very familiar, somewhat familiar, or not familiar. So again, just to get you to select your choices there. It's great to see so much engagement in the polling questions. Everyone is in tune and following along. Okay, I'm just going to give it a few more seconds to have a look and for people to indicate what their choices would be there. Okay, I think we just push that one to the audience. So we had about 23% who were very familiar. Again, roughly around 65% who were somewhat familiar, and about 13% who were not familiar. All right. How familiar, our next polling question is how familiar are you with the Social Workers Act? Again, the options are very familiar, somewhat familiar, or not familiar. So again, just give everyone a few moments to indicate their choice there in terms of familiarity with the Social Workers Act. And the polling responses are coming in, so that's wonderful. It's always good when we see the numbers coming in because sometimes we don't see what you see on your end. So we just want to make sure the polling questions are working properly, and it seems they are because we are getting a high number of participants who are participating in these polling questions. So I do thank you for that. All right, I think we've kind of stopped. So we have about 40% who indicated they were very familiar, 53% who were somewhat familiar, and 6% who were not familiar. Okay, great. Thank you, everyone. And another polling question, we're not finished yet. How familiar are you with the NLCSW standards of practice? So would you say you're very familiar, somewhat familiar, or not familiar? So again, just to give you a few moments to indicate your choice there. I want to thank everyone for engaging in these polling questions. It's wonderful, wonderful engagement. And lots of responses coming in terms of each polling question. So that's really great. Okay, I give you another second. Okay. All right. So we had about 70% who were very familiar. That's excellent. 31% roughly who were somewhat familiar, and no one who said they were not familiar. So that's fantastic that everyone's familiar, has somewhat familiarity with the standards of practice. All right. And of course, we have our 2024 new code of ethics that was implemented last year. So, how familiar are you with the CSW Code of Ethics values and guiding principles? Would you say that you're very familiar, somewhat familiar, or not familiar? So, again, just give you some time to complete that. So, our standards of practice were also updated in 2024 to coincide with the release of the 2024 CSW Code of Ethics. So, of course, those are the documents here in the province that social workers use in their practice and guide their social work practice here in the province. So, again, just to give you another few seconds there. Okay. Getting up and higher in our numbers there. So I'll just give you another 2 or 3 seconds to get your answers in. Okay. So we had about a little over 71% who noted they were very familiar. So that's excellent. And about 28% who were somewhat familiar, and only less than 2% who noted they were not familiar with the CSW Code of Ethics values and principles. So thank you again for that. And we're going to keep going with some polling questions here. So I do thank you for your engagement. The next poll that we have is how familiar are you with the NLCSW website that provides links to documentation resources? In particular, looking at documentation, are you very familiar, somewhat familiar, or not familiar? So again, same thing, let you have an opportunity to put in your choices for this particular poll question. Okay. Seeing the numbers come in, that's fantastic. Wonderful. And there is a link that was included in the resource section on the webinar platform to all the section on the NLCSW website that has the documentation resources for anyone who's not familiar. Okay, I'm just going to push this to the audience. So we had about 75% who noted they were very familiar, about 22% who were somewhat familiar, and about 4% who were not familiar. So again, if you're not, I encourage you to use that link that we provided in the resource section on the webinar platform. And also go to the website at www.nlcsw.ca. Okay, so our next polling question is, this is more for you to think about your own practice. How often do you struggle with decisions about how vague or explicit to be in clinical notes, given who might have access to your notes? Would you say this happens very frequently, somewhat frequently, not very frequently, never, or is just not applicable to you in terms of your particular area of practice? So again, just give you a chance to think about that and provide your options, so that it's how often do you struggle with the decision in terms of how vague or explicit to be in your clinical notes. Just give you some more time there. See the numbers coming in quite fast, so that's excellent. Thank you once again. Give you a few more seconds in terms of providing your response there. Okay, a couple more seconds. Okay, so I'm just going to push this one to the audience. So we had close to 11% who had said very frequently, about 44% who noted somewhat frequently, 40%-ish, not very frequently. We had less than 2% that said never, and less than 4% that said it was not applicable. So the majority were, fill in very frequently to somewhat frequently. Okay. We're almost through some of our polling questions, but we do have a couple more. Our next polling question is, how familiar are you with the difference between a subpoena mandating disclosure of client-related documents and a court order to disclose documents? Would you say that you're very familiar, somewhat familiar, or not familiar? So again, just to give you some time to think about that and provide your responses there. Okay. Responses are coming in. That's wonderful to see. A few more seconds there. Okay. 3 more seconds. Okay. All right. So we had about 10% who were very familiar, 27% who were somewhat familiar, and 63% who were not familiar. So again, thank you all for that. And now we'll move along to our second last polling question. So 2 more. So we want to keep your engagement here for another little bit for the polling questions. But how familiar are you with the difference between privileged communication rules and confidentiality rules governing disclosure of clinical records? Would you say you're very familiar, somewhat familiar, or not familiar? So again, just for everyone to have a chance to provide their response. Again, seeing the numbers come in. Give you a few more seconds, noting that there is that delay between what you're seeing potentially on your screen. Okay, 3 more seconds. Okay. All right. So we had about 10% who were very familiar, 37-ish percent who were somewhat familiar, and 55 roughly percent who were not familiar. So thank you. And now we'll go to our last polling question. To what extent do you agree or disagree with the following statement? Documentation is one of the least appealing aspects of my job. Would you say you strongly agree, disagree, strongly disagree, or it's not applicable to you? So, last polling question. So, lots of responses here. Seeing the results come in. So the question is, do you agree or disagree that documentation is one of the least appealing aspects of your job? Okay. Lots of responses coming in. That's fabulous. Maybe a few more seconds. Okay, 3 more seconds. Okay. All right. So we had about 21% who strongly agreed. We had 41% who agreed, 29% roughly who disagreed, almost 7% who strongly disagreed, and almost 3 where it was not applicable. So the majority either strongly agreed or agreed with that particular statement. So that's the end of our polling question. So I'll put it back to you, Dr. Reamer.
Great. All right. So I'm not going to comment on the results here because we do need to take a break, but very illuminating responses. Let me just echo what Annette said. Thank you for engaging with that. With regard to that last item, I am not surprised that about 3/5 of you say that documentation is one of the least appealing aspects of your job. I encounter that pattern very frequently, and I understand it. I'm not critical at all. I don't want to comment on some of the results here because we do need to take a break. But when we come back, I will comment a little bit on some of the poll results, and then we'll shift gears. It is 7 minutes after the hour where I am. We're going to take a 15-minute break. It is what, Annette, 37 minutes after the hour where you are?
Yeah, it's 11:30. Just turned 11:38 here.
Very good. Very good. So we are going to resume promptly in 15 minutes. Promptly in 15 minutes. I will see you then. Have a good break, folks. All right. It is time to resume. And again, I want to thank you for participating in the poll questions. Clearly, there are some differences of opinion among you with regard to some of these issues, some variation among you with regard to your familiarity with Canadian law and code of ethics standards for social workers. Some of you report that you do often struggle with decisions about when to be vague or not vague in notes. So I actually want to make a comment about one of those issues. But before I do that, Annette, any housekeeping details, anything you need to share before I resume?
No, you can proceed to go on, and you just need
Okay.
to press next to go to
Yep.
your next slide, and yeah, we're good to go.
Terrific. Thank you. So I do just want to comment on one issue that several of you raised in the Q&A. I didn't have time to read all of the questions, but it relates to one of the poll questions. So I want to take just a moment to share with you the way I think about a difficult documentation decision. So I gave you the example of the client who's in recovery, who shares with the social worker that 7 years earlier, he, the client, committed a murder. And on the day the client disclosed that to the social worker, in the social worker's judgment, the client is actually doing very well. He's been in recovery, he's addressing his trauma issues, he's doing the hard work. And several of you put in the comments, Q&A, that, and I'm paraphrasing here, of course, that you would think that maybe you would have a duty to disclose the murder, that that's not confidential. I'll share with you my opinion, because I think this is a wonderful illustration of how complicated documentation decisions are. Feel free to have a different opinion, but I've been down this road many times, and I'd like to share my thinking with you. In my opinion, if on the day of the disclosure by the client to the social worker, on that day, if it's the social worker's judgment that the client is doing well, the client does not pose an imminent risk to the public, he does not, imminent meaning soon, he does not pose a serious risk to the public, he does not pose a foreseeable risk, imminent, serious, foreseeable risk on that day, in my opinion, that social worker, number one, is not permitted to disclose that information without client consent. If the social worker believes that he, she, or they have a duty to disclose that information and they do disclose it, in my opinion, if I'm the expert witness, that social worker made a profound error in judgment, disclosed information without proper consent. And if that information is used against that client to prosecute that client, I believe in the United States, that client would have very strong legal grounds to go after that social worker because of the lack of evidence of imminent, serious, foreseeable harm. Moreover, I would argue, and again, I want to clarify, I'm not minimizing the seriousness of a murder. Of course not. But I'm balancing that with ethical duty on the part of social workers. In my opinion, as I suggested earlier, that note should be vague. Client disclosed details about a past traumatic event. Shared feelings of guilt and remorse. We discussed managing those feelings. I believe that note must be vague because I need to think like a chess player, to go back to that analogy, and anticipate the possibility that those notes might be subpoenaed, ordered disclosed for some other purpose, and that any details about a murder could be used against the client. So I'm going to share something with you to back up my opinion. So let me find, all right, so I hope I am now displaying the CASW Code of Ethics. So Annette, can you just confirm for me that the code is up there?
Yes, yep, it's up
Okay.
there.
Okay. And Annette, please jump in here because I'm not Canadian. I don't want to get any of this wrong, but I'm going to tell you what my impression is. So this is, just to show you folks, this is the Code of Ethics, Values and Guiding Principles 2024. If you go down to section 6, value 6, maintaining privacy and confidentiality, okay? It says, social work, let me see if I can make this a little bigger for you. I guess that, yep. 6.4, social workers disclose confidential information, think about the murder details, with valid consent, okay? You don't have client consent here, presumably, in accordance with applicable legislation or without consent when required by law or court ordered or allowed by legislation. So now let's go down and take a look at, let me find the right spot here. Here we go. Let me find the right, I just want to find the exact standard. Here we go. I'm right down here. 6.4.10. 6.4.10. Will act based on the assessed level and or imminent or foreseeable risk. See that those words? Imminent or foreseeable risk. So this is similar in some respects. The wording's a little different. from what's in the National Association of Social Workers Code of Ethics in the US in Standard 1.07c, which I was privileged to draft. And in the United States, Section 1.07c, Standard 1.07c, says pretty much the same thing, that a social worker is only permitted to disclose confidential information without client consent if the disclosure would likely prevent imminent, serious, and foreseeable harm to the client or third parties. Now, the Canadian standard, 6.4.10, refers to imminent or foreseeable risk. In the US, we have the added words serious in addition to imminent and foreseeable. But I would argue the gist of it is the same. So it would be my opinion, based on my interpretation of the CASW Code of Ethics, Values, and Guiding Principles 2024, that a social worker who discloses that information without client consent in the absence of evidence of imminent and foreseeable risk on the day of the disclosure would be violating the client's rights, and that would expose the social worker to considerable risk. Annette, I don't know if you want to comment on that at all, but that's my opinion. As an illustration of a complicated ethical decision-making around documentation.
Yes, no, that was a great response, Dr. Reamer. And we had actually had our ethics committee. I don't know if people who are online would have read an article that our ethics committee had in Connecting Voices back in 2019, where we looked at, when personal morals and professional ethics collide, and we cited Dr. Reamer in that article as well. But kind of looking at it because, you're right, Dr. Reamer, they're so complex. So we really have to work through that ethical decision-making framework and look at, okay, what is the code of ethics telling us? What is the standards of practice telling us? And to kind of pull out those sections from the code in terms of our decision-making around, like I said, limits to confidentiality, informed consent, all those pieces. And there's certainly an element of consultation around that too, if you're struggling with that in terms of consulting with a peer, with your supervisor, having those conversations around what is my duty here, because there would have to be that understanding of what the relevant legislation is as well, because we know there's mandatory reporting for child protection, for example, or adult protection. So what is the legislative duty there that you're looking at in terms of that piece? And certainly, a legal consult if you're really struggling with that as well, to seek that legal guidance around, is there a legal requirement here? And then that can help inform the decision making, looking at the ethics, the legalities, and then of course, as a professional, your own decision making around that, but that there's lots of resources and guidance that you can get if you're really struggling with that as well, right? So that's just kind of what I would put in there. But I do remember, and I'll quote you, Dr. Reamer, in the article that we had, because you wrote an article on this as well, on Hobson's choice in social work ethics, where you said social workers must be mindful of the important distinction between what they believe is the right thing to do in the midst of an ethical dilemma and what they have a right to do. So I think comes down to that in terms of looking at all of that and looking at your code of ethics, looking at the standards of practice and making decisions based on your, professional obligations and whatever legal obligations that you might have, right? So it's often not a clear yes, no, because every situation could potentially be different. So it's hard to give a yes or no answer. But yeah, I just thought I'd put that little piece in as well. So great response, Dr. Reamer.
Well, thank you, and for your eloquent statement, Annette. And I'm so impressed that you actually remembered what I said in that article and Hobson's choice. So that's great. And while we're on the subject, for those of you not familiar with these resources, if you go to the NLCSW website, which I hope you see on the screen there, and you click on social workers, and you click on codes and standards, you will see a lot of information there that can be very helpful to you. In addition, if you go down to practice support and you go to resources, Annette, I hope they can see what I'm doing here as I'm scrolling through. Is that coming
Yes.
up on the screen? Great. So if you go to the NLCSW website under practice support on the left, and then resources, and then you'll see all these topics here, including documentation and recording. And Annette and her colleagues have done a great job of putting together all kinds of resources related to today's topic, documentation, in addition to links to other resources that you may find helpful related to ethics, electronic practice, and so forth. And I don't know if you want to comment on this website at all beyond what I've said.
No, I think you've covered it, and we continue to ensure that we have lots of resources there. And if we get a question from a social worker, chances are there's 10 more social workers with the same type of question. So we generally try to look at what some of the themes are and questions, that are coming in, that we can provide some, and where we can provide that guidance based on, a code of ethics and standards of practice. So everything that you would find on that particular section of the website are grounded in the code of ethics and standards of practice, and are meant to provide a reflection, an opportunity to reflect on and ask those important questions. Like I said earlier, it might not always be yes or no, but it's about that process of engaging in that reflection, that thoughtfulness, and considering all the ethical elements to a particular situation.
So let me just reinforce something Annette said, and I'm going to revisit this theme later. She just said there may not be a clear yes or no. There may be reasonable difference of opinion. And that is, in my experience, absolutely true, including documentation decisions. And I'm going to talk later about how I think often when there's a complicated documentation decision, should we be vague? Should we not be vague? Who should have access to these records? Consultation is critically important. And on some of these issues, reasonable minds may differ. I think that's a key phrase. On some of these issues, reasonable minds may differ. Reasonable minds don't differ on whether it's okay to commit fraud. Okay, that's not something we disagree about. But on some of these issues, I think there's room for disagreement. And what I find is when there's not a clear yes or no answer, the steps we take to make that decision, including what Annette said about consultation. And I'll get into this in much more detail later. That process is often what's most important. The steps we took, even if in the end, reasonable minds may differ. Okay, so thank you, Annette, for that. And I just do want to say, I'm not saying this to be polite. I'm saying it because I believe it to be true. During my career, I've had the opportunity to look at lots of licensing board, regulatory body websites throughout the United States, the different Canadian provinces. I've had the opportunity to consult and visit many countries. I've traveled to India and South Korea and China and Singapore and Taiwan. I mean, all kinds of places, European countries. And so I've seen lots of websites designed for social workers. The NLCSW website is terrific. It is among the best I've ever seen. It's detailed, it's comprehensive. It's a great, great resource. And again, I'm not saying that to be polite. I'm saying it because I think it's true. So congratulations and kudos to Annette and colleagues. All right, so let me shift gears here. You see on the screen, I hope, a slide that says standard of care. The concept of standard of care, I think, is critically important for social work in general, and with regard to today's topic, documentation in particular. The concept of standard of care is rooted in the law. First, the United Kingdom, the US, and as I'll show you shortly, it's embedded in Canadian law as well. As I said earlier, I'm not an expert on Canadian law, not by a long shot, but I've done some research, and it is my opinion that the way we understand the concept of standard of care in the US is very similar to the way Canadian lawyers and judges understand the concept of standard of care. In the United States, the concept emerges in a major case that originated in the state of Maine involving a dispute between an architect and the architect's client. It had nothing to do with social work. But the court decision that reached the Supreme Court has everything to do with social work, I argue. In the case called Coombs versus Bede, a family, the Bede family, hired an architect, Coombs, to design a house they wanted to build in Lewiston, Maine. And if you read all the details in this case, the architect drew up the plans the way architects draw plans, and the family did not think the architect did what they asked him to do. Particularly, according to them, the house could not be built within their budget. So reportedly, the family gave the architect a dollar figure. Here's what we can afford to spend. Please design a house within our budget. The family looks at the plans and concludes, nah, that's beyond our budget. They refuse to pay the architect's bill. It's a very interesting case, having nothing to do with social work. But here's what the Supreme Court ruling said. It's basically a fee dispute. It goes all the way to the Supreme Court. And if you know how the law works, cases that reach the Supreme Court then focus on questions of law, interpretation and application of law, as opposed to the facts themselves. And here's what the court said. And I'm paraphrasing, but this is pretty close. Whenever there is a dispute about what any professional should have done in a particular set of circumstances, any professional, a doctor, a dentist, an engineer, an architect, a social worker. What the court said, and by the way, this Supreme Court decision was issued in the 1890s. 1890s. That's how old this thing is. What the court said is that the measuring rod is this concept of standard of care. Defined generally, and in the United States, every jurisdiction defines it in its own unique way. But if you sort of take a look at these definitions from 30,000 feet, what you see is what I have on this slide. That the measuring rod is what a reasonable and prudent, notice the italicized words in red, what a reasonable and prudent practitioner with the same or similar training should have done under the same or similar circumstances. Reasonable. It doesn't say the most skilled practitioner, however you define that, if it's even definable. It says a practitioner who's reasonable. Notice the prefix of that word, reason. You think it through. It goes back to what Annette said. In a complicated case, you're expected to think it through. Reason. Able to reason. Reasonable. Prudent. Careful. Cautious. That's the typical dictionary definition. So let's apply this to social work. As someone who gets involved as an expert witness in many, many cases, I am always asked to look at the evidence and to render my opinion about whether the social worker met the standard of care or fell below the standard of care. That is the question I always get. Did the social worker manage confidential information in the way that a reasonable and prudent social worker would in those circumstances? Did the social worker manage boundary issues and dual relationships and conflicts of interest the way a reasonable and prudent, careful, cautious social worker would have handled those challenges? Now let's apply it to today's topic, documentation. I've already said, in my opinion, we have lots of documentation decisions to make in social work. Who should have access to our records? Under what circumstances? Take the example involving the murder. Should you be vague or explicit in the notes? Right? Do you have a duty to disclose that information? All these decisions we make about who has access to our notes, when to be vague, when not to be vague, the short note, the long note, these are decisions governed by standard of care. So I would argue, so often with regard to documentation, our goal is to meet the standard of care, to think it through before we write the note. If it's an electronic record, before we hit submit, before we lock that note, let's think it through. Let's reason. Let's be careful. Let's be cautious. Let's be prudent. Let's think about what the standards are regarding these particular circumstances. The client who discloses 7 years after the fact that he committed a murder. Let's take a look at those circumstances, as opposed to, let's say, an adolescent client who says, social worker, I'm really struggling with sexual orientation issues, gender identity issues, but I don't want my parents to know this at this point. And thinking like a chess player, the parents may have access to your notes. My opinion, an adolescent client who's struggling with those issues is not yet ready to disclose that, but wants to talk to the social worker about how to handle all these feelings. I think that social worker should be vague in the notes, because parents typically have a right to those notes. However, if the adolescent says, and I am so miserable, I am so tortured because I think my parents would have so much difficulty if I tell them that I'm gay, I'm lesbian, bisexual, whatever, that sometimes I think the adolescent says that life isn't worth living, then I'm a social worker who's thinking, is my client engaging in suicidal ideation? And I do my risk assessment consistent with standard of care. There's a way to do that, of course. My notes about the suicidal ideation, if I think it's there, they will not be vague. My notes about the gender identity, sexual orientation, I can be vague about that. Client disclosed feelings and thoughts about identity issues. Fine, no problem, in my opinion. But if I have evidence of suicidal ideation in conjunction with those thoughts and feelings, I cannot be vague in my notes. That's where I draw the line. Those are the threshold criteria, in my opinion, when the documentation must reference health and safety issues. So I think this sentence on this slide is profoundly important. That in documentation decisions, we should always aim for what we consider to be reasonable documentation, prudent, careful, cautious documentation in those circumstances, given standards in social work. And it's going to take me a moment to pull it up, but I want to show you something else. So, and here we go. I found it. Okay. So, Annette, I hope you can see on the screen, it says standard of care. A document written by, thank you, Brenda Osmond. I don't know Brenda Osmond. No idea. I really don't know her. But this is a Canadian website on the subject of the standard of care. Okay? This is a third article in a series on malpractice litigation. It's focusing on medical malpractice, but that's fine. It applies everywhere. And it says, let me make this larger. It says right here, according to her, and this is entirely consistent with what you find in the United States, the law does not, this is a Canadian author, does not expect healthcare professionals to provide the highest level of care. That's not the expectation, which is why the word reasonable is in that sentence I showed you, or to meet a gold standard in providing care. That is not the expectation. Rather, Canadian practitioners, I'm paraphrasing, of course, are expected to exercise the reasonable degree of care that would be expected. There's that word right there, same as US law. Reasonable degree of care that would be expected of a normal, and there's that word, prudent practitioner. You can see it says right here, at its heart, the standard of care, and again, it's referring to medical malpractice, but I assure you the same thing applies to social work, is no different than any other torts action. A tort is a personal injury claim. The plaintiff, the party bringing the suit, must prove that the defendant breached the standard of care in Canada. This involves determining what the standard of care is and if the defendant, and I'll add social worker, breached that standard. Okay? And then it cites Canadian court rulings. right? The concept of reasonableness, there's that word again, pervades the court's determination of the standard of care as evidenced by the following statement from Sylvester versus Kritz. I am guessing that's how you pronounce that. Every practitioner must bring to his task and her task and their task a reasonable degree of skill and knowledge, and must exercise a reasonable, see how often that word reasonable shows up, degree of care. Bound to exercise that degree of care and skill which could reasonably, there's that word again, be expected of a normal, prudent, there's that word prudent again, practitioner of the same experience and standing if he holds himself out as a specialist, social worker, et cetera, et cetera, et cetera. So I'm not going to read this whole thing. But clearly, at least it seems to me, Canadian law resembles US law with regard to this critically important concept. And I think this concept is directly applicable to documentation decisions. And in law, and I believe this is true in Canada as well as the US, if there's a lawsuit alleging that a social worker didn't handle documentation properly, they were negligent. So take the murder example. Let us suppose some of you decide, A, to disclose the client's disclosure of the murder, and you document it, contrary to my opinion of what should happen, but let's suppose that's what you decide to do, and several of you in the Q&A suggested that that was your instinct. Let us suppose you do that. In my experience, you just painted a target on your back. And the client, probably a former client at this point, would have grounds to sue you for failure to protect privacy and confidentiality, for unauthorized disclosure of confidential information. And in negligence law, there are 4 elements. The plaintiff, your former client, presumably, would have to show, number one, that you had a duty. Well, you're a social worker. This is your client. That establishes a duty. That one's easy. Second, that there's evidence of a breach or dereliction of duty concerning documentation. Why did you put those details in your notes, knowing that your notes could end up being disclosed to third party? The argument from the plaintiff is that's a breach of the duty. You had a duty to be vague. The third element, harm or injury. In the law, and I know this to be a fact in US law, and I think it's true in Canadian law as well, a negligence case has to include evidence of harm or injury. So if that client, former client, is charged with murder, right? Tried, sentenced, imprisoned, that's harm, that's injury. And what lawyers call proximate cause or cause in fact, there's evidence of an uninterrupted causal connection between the breach of the duty by including these details in the notes and the harm, the prosecution, conviction, incarceration of the client. These are the negligence cases I see. Now, in negligence law, a breach of a duty, and this pertains to documentation, can occur in 2 broad ways. What we call acts of commission, details we put in our notes that should not have been in there in the way that they are in there. It can take the form of misfeasance. What's that? The wrongful exercise of lawful authority, performing a proper act in an injurious manner, including details about the murder, not fully understanding what the implications are down the road. That's misfeasance. That's a proper way to document, but allegedly that's misfeasance. Notice the prefix of the word misfeasance, MIS, like mistake. No coincidence there. Malfeasance. Mal, I know there's a lot of French in Canada, so a lot of you know what mal means, bad, sick in French. Malfeasance in documentation, an act of commission, is wrongdoing. Performance of a wrongful or unlawful act, fraudulent documentation. Documenting sessions with a client that never happened to generate revenue. That's malfeasance. And then there are acts of omission, or what's called nonfeasance. By lawyers, oh, you didn't document your conversation with psychiatrist Dr. Smith. It's not in there. You say you did it. You say you consulted. You say you consulted with Annette. You called the NLCSW office, you spoke to Annette, and here's what she said. That's what you testified to, but it's not in your notes. That's an act of omission, an act of nonfeasance. So before we take the lunch hour, 45-minute, but not hour, 45-minute break, I want to cover a couple things. And we will provide time later for your comments, your questions. I'll ask Annette and or Wendy to go through them and to pull some out. We'll allocate some time for that. But I want you to take a look at this slide, the relevance of documentation during legal proceedings. This is one example of what's called a notice to produce. What attorneys issue when they want social workers' documentation. And it's not necessarily only your clinical notes. It could be email messages, text messages, online social networking posts, what we now call, as I said earlier, ESI, electronically stored information, which, by the way, didn't exist when many of us, myself included, started our careers. When I started my career, all my notes were recorded using one of these things. This is called a pen. It is something we use with stuff called paper. Anybody recognize pen and paper, right? We know from the poll questions, so many of you are using electronic records now. So a notice to produce, it would take, 4 minutes or so to read this whole thing. Lawyers want everything when they subpoena documentation. They issue a notice to produce. This is just to show you in the United States, just by way of example. I referenced this earlier, we now have a very strict federal law that requires social workers to make available to clients social workers' electronic records when clients want them, right? In Canada, you have a law that refers explicitly to, and I'll just read here, the Personal Information Protection and Electronic Documents Act. The Personal Information Protection and Electronic Documents Act. Right? There's a lot of stuff in Canadian law about the management of electronic documents. So before we take the break, I'm going to do this very quickly. Some years ago, I wrote a book at the request of the National Association of Social Workers entitled The Social Work Ethics Audit. In that book, I provide an overview of the steps I think social workers can take to assess the quality of their ethics-related policies and protocols in a number of areas related to management of confidential information and boundaries and dual relationships and conflicts of interest and termination of services and informed consent. And one of those areas is documentation, today's topic. And in this book, I say, I think it's a good idea. Is it fun? No, but I think it's a good idea for social workers to take a close look at their documentation protocols in two forms: their documentation policies and their documentation practices. And I make the distinction because, in my opinion, our policies in social work sometimes are pretty darn good, but our implementation of the policy sometimes not so good. In other words, sometimes there's a disconnect between our documentation policies and protocols. I'm not saying you have to do a formal audit like this, but in this book, I lay out like a 4-point assessment tool: no risk, minimal risk, moderate risk, high risk, self-explanatory. I then provide some discussion of all the different kinds of documentation policies we ought to have in social work, in my opinion, what we ought to be documenting by virtue of our policies. And then I think, ideally we take a look at our policies and assess whether they're like in great shape, no risk, a little bit of tweaking necessary, minimal risk, moderate risk, high risk, and the same thing with regard to documentation procedures, what actually happens, the extent to which the agency, the practitioner, has appropriate procedures in place to ensure proper documentation. No risk, minimal risk, moderate risk, high risk, with regard to, again, the sorts of things we ought to be documenting. So I want to say just a word about the fact that, in this day and age, of course, we're now providing lots of services remotely. And I'm not going to go through all these slides. There simply isn't time. But we now know that if we're providing services remotely, which a lot of social workers were doing before the height of the COVID-19 pandemic, it's accelerated, I think, because of the pandemic. We're now much more comfortable providing services remotely, particularly to people who live in very rural sections of Canadian provinces and territories. Our informed consent protocols, our documentation of our informed consent protocols, I think needs to be consistent with standards of care. They have changed. Standards of care regarding consent to treat when we're providing services remotely. We need to have really good documentation spelling out what exactly telehealth or telebehavioral health means and what the potential benefits are and the potential risks and the ways in which electronic communications can be intercepted. And we need to confirm the client's location if there are licensing issues. And it can be technology failure. We all know that can happen. And all this stuff needs to be documented. This is an example of how standards of care have changed. Okay, and these 3 slides, which you can look at your leisure if you'd like, detail what I think ought to be included in documentation of our consent to treat when we provide services remotely. Okay, several slides going through all this in considerable detail. It's time to take our 45-minute break. When we come back, Annette and Wendy, I think it might be a good idea to spend a little bit of time taking people's comments, questions, if you have the time to peruse those. And then I'm going to talk some about electronic records, what I think some of the particular risks are associated with them. And Annette, anything you want to say before we take the 45-minute break?
Yeah, no, I just want to say the session's going fabulous so far. Thank you so much. So much great information being shared. So we will take a break. But if you do have questions specific to social work documentation, make sure you get those in the Q&A chat there now. We are getting lots of ethical questions, and we could spend a whole day, I think, just talking about ethics and some of the complexities in our work. And that goes part and part. But if you do have any particular questions around social work documentation as well, to focus on, that would be great. So pop those in the Q&A using the Q&A widget, and we'll get to those questions a little bit later on. So thank you.
Terrific. All right. So my understanding, Annette, correct me if I'm wrong, that we are going to resume at 1:17. I spilled over by 2 minutes. Sorry about that. We'll give them back to you. We'll resume at 1:17 your time. Did I get that right?
Yes, that's correct. 1:17.
Okay. All right.
Yep. Enjoy lunch, everyone.
Have a good break.
All right.
All righty. Hope you had a good break there. I hope you have enough fuel left in your tank for some more discussion of these issues. As I said earlier, I recognize it can be a rather dry subject, but I hope you are appreciating how complex this topic is. I know it can be a challenge sitting in front of a screen for 5 or so hours. I hope it's been worth your while. So before I dive back into the material, I want to ask Annette and Wendy whether there are questions or comments they'd like to share based upon what they're seeing in the chat.
Perfect. Thanks, Dr. Emer. So welcome back, folks. So yes, first of all, we did look through the Q&A, and I spent some time looking through the Q&A in the chat, and we've gathered together some themes, and some of those themes aren't directly related to documentation, so we are going to consider those for potential future sessions. But we certainly do encourage people to keep using the question widget to ask questions in relation to the topic of documentation specifically. One housekeeping piece is that folks are asking around the resources. There was a little bit of a glitch this morning, but that has been fixed, and you can now find the slides under the resource widget on the platform, so they should be there now. Okay, so Dr. Reamer, in terms of a couple questions, we came up with two that we summarized, kind of the themes. The first question is, can you comment on some things to consider when using an electronic documentation platform?
Yeah, well, Joy, boy, you'd think we rehearsed this, because the slide that's on the screen right now, slide 47, these are do's and don'ts regarding electronic records. And I won't take the time to go through all of these do's and don'ts. So just to show you, it's slide 47, slide 48. Lots of suggestions regarding things like, don't copy and paste unless you are absolutely sure what you're copying and pasting is accurate. I shared that anecdote with you before. Things like, be sure that at the end of a session that where you're entering notes, be sure you log off, because if you don't, this is based on like actual cases. If you don't log off and somebody else gets on that computer and enters notes for somebody else, they're getting entered under your name. So anyway, there's a bunch of odds and ends here. Auto population. Let me mention that. So the case I mentioned earlier that I testified in Illinois, that case, this is the very sad case involving the 18-month-old who was allegedly murdered by his mom, who is the client. And what a glitch in that case had to do with auto population. What does that mean? With some electronic health record platforms, certain fields automatically populate when you open up the chart for that day. And so dates will automatically populate in certain fields. Well, in that case in Illinois, there was a glitch. There was a field that where auto population shouldn't have happened, but it did. And a staff person wrote a note at the beginning of services. So to refresh your memory, social workers and others provided services for 15 months in that case. And a staff person wrote a note at the beginning of the 15 months after doing a comprehensive assessment, basically saying, and I never would have written this sentence, I would advise against it, but this person did, basically saying, in that staff person's opinion, it was highly unlikely that this mother would be able to parent this child, given her history. I don't believe in forecasting. I think it's a mistake in documentation to forecast outcomes. I know in my experience, too often I've guessed wrong. What we call in statistics, type 1 and type 2 errors, false positives, false negatives. I can think of cases I've been involved in. You may have heard Annette say at the beginning, I've spent much of my career outside of academia working in prisons. I spent 24 years of my career on a parole board deciding who stays in prison, who gets out of prison. And there were cases where I was so confident that the inmate would do well in the community. Didn't turn out that way. And there were instances where I thought an inmate, if released, would not do well. That person ended up being released and did remarkably well. So these things happen. I don't believe in forecasting. But in the Illinois case, a staff person wrote a sentence basically forecasting that, in her opinion, it was not likely this mother would be able to parent this child. And the date, this is the auto population problem, the date on that note kept changing. Every time the record was opened, the date changed to the current date, which meant 15 months later, when staff recommended that the child be placed with the mom, there's a note by a senior staff person saying this mom probably shouldn't be parenting this kid. And the date was for that week. Well, when I was on the witness stand, the lawyer for the family, plaintiff's lawyer, put that note up on the screen, put the date up on the screen, had me read it into the record. I knew this was going to happen. This was not a surprise. And basically said, Dr. Reamer, how can you defend this agency when one of its staff wrote that note the very week when the child was placed, mom allegedly murdered the kid, and all that. And I said, counsel, which is how you typically address a lawyer in the courtroom, at least in the US. I said, counsel, in my opinion, that's a documentation error. And I explained the problem of auto-population. Nobody caught that with the electronic record software. And he turned to me and he said, Dr. Reamer, can you prove that? And I said, no. And that is the case where the jury came back with a $45 million US dollar verdict. So anyway, this slide includes some do's and don'ts. The next one has to do with client portals. These are electronic records. Issues around remote access. And you can sort of read that for yourselves because we don't really have the time to go through this in great detail, but a lot of very practical advice. Just as one example, if you're providing services to a minor, does the parent under Canadian law have a right to access your notes, right? The parent has a right to have a username and a password. And should you write every note, assuming with an electronic record that a parent or legal guardian can log in? And I don't know whether Wendy or Annette, you have any comments on that particular issue, given your understanding of Canadian law and parents' access to records. But that's an example how you've got to be really careful.
We are within NL Health Services now moving to MyChart. So we're I would say behind jurisdictionally in terms of direct access and logging in. So we're just at the cusp of kind of with the electronic chart of doing what I understand is the case in other jurisdictions and the states as well.
Okay. All right.
And just a note, I shared it in the group chat earlier. Someone had a question, but we do have a guideline document around informed consent when working with children and youth. And I provided the link to that so people online can have a look at that document as well in terms of all those informed consent documentation type issues with children and youth.
And that's accessible on the NLCSW website, I'm guessing, Annette?
Yes. Yeah.
Great. That fabulous website I told you about earlier. So check it out.
Okay, thanks for that, Dr. Reamer. So the second question is, can you share your opinion on when and where to add clinical impressions in documentation?
Oh, okay. So I'm going to get into that because where I'm headed in our remaining time, I have a series of tips that I want to share with you. But I'll just fast forward. I'll just answer the question and then I'll revisit it a bit later. So I think it's fine to share clinical impressions with regard to things like depressed mood, anxiety, risk of relapse, whatever it happens to be. However, this is a huge however. I, based on my experience, would never say something like, client appears to be clinically depressed. Client appears to be overwhelmed with anxiety or something like that. That's a clinical impression. If I use any of that kind of language, I always recommend putting a comma after that phrasing, appears to be clinically depressed, comma, and then 3 words. Now, do they have to be these 3 words? No. But I think these are the 3 words you might consider using. And the 3 words are as evidenced by, as evidenced by, as evidenced by. And you follow those 3 words with the behavioral indicators, whatever other data on which you are drawing to reach that conclusion. So, presumably we're trained to share, to assess clinical risk and clinical status. That's our training. We have expertise, fine. I think it's fine to share those impressions, but I would always include those words or something like those words as evidenced by, and then I would include the details that support that conclusion. Might somebody quibble with you, argue with you, disagree with you, saying, gee, I don't think you had sufficient evidence to conclude clinical depression. And you can have that debate. But if you don't have the supporting wording in the note, I think you open yourself up for problems.
Wonderful. Thank you. I'm now going to hand it completely back over to you, Dr. Reamer, to continue, because it sounds like a lot of these questions are probably going to be answered as we move forward.
All righty, let's do it. Okay, so I'm just showing you this briefly. This pertains to the U.S., but I think it's an important message. In the U.S., behavioral health providers are encouraged to conduct privacy audits. We have legislation, very strict federal legislation called the HITECH Act, which stands for Health Information Technology and Economic and Clinical Health. That's a mouthful. That lays out the kind of assessment behavioral health providers should conduct to be sure that their documentation, again, today's topic, is kept appropriately private, right? I'm not aware of any comparable requirement in Canadian law. Perhaps Annette and Wendy are, but I'm not. I looked for it, I couldn't find it. But I wanted you to know, just as an example, that there's a very strict standard in the US concerning this concept of a privacy audit, what it includes, how to conduct a privacy audit. And even if it's not required under Canadian law, the slides here about what's included in a privacy audit regarding protection of documentation might be helpful to you. All right, let's continue. So I mentioned that I want to share some tips with you during the remaining. And I've drawn on everything I've learned over the decades to put together a series of tips that I'm going to run through. I've already mentioned a few of these issues, others I've not. So tip number one. You know how I've said several times, I don't think it's accurate to say less documentation is better than more documentation, keep it vague. If ever that was the advice, I think it's not current advice. I don't think it's sound advice. So what I argue is that we ought to aim for a reasonable balance between including too much information in our notes and not enough. We got to thread that needle, and that's a judgment call, right? I argue we ought to include information that's essential, and I highlight that word essential. It's necessary in order to be accountable to multiple parties. To the client, obviously we're accountable to our clients who have a right to see our records under most circumstances, some exceptions. Accountability to our colleagues, to our employers, third-party payers, utilization review organization, courts of law. And my instinct is to avoid including what I call gratuitous information. Why do I pick that word gratuitous? So you know what a gratuity is. A gratuity, like if you go to a restaurant, at least in the United States, you know, we have a choice as restaurant customers about whether to leave a tip, a gratuity. It's a gratuity. If we don't like the food, the service is bad, we might not leave a generous gratuity. If you don't leave a gratuity and you walk out of the restaurant, you cannot be charged with a crime. It's up to you. But if you don't pay for the food and you leave, that's called theft. You can't do it. So in documentation, I refer to gratuitous information as information we do not have to include. It's not necessary to include it. And it may not be a good idea to include it because it's so sensitive. It's not essential. It's not warranted. So I'd be very careful to avoid including what I consider to be gratuitous information. I limit myself to what I consider to be essential information. And I think there are instances when I'm inclined to be less detailed in documentation. If it's gratuitous, it's not essential. Kind of a cute little rhyme. I say, when in doubt, leave it out. When in doubt, leave it out. If it's potentially embarrassing information, if it gets disclosed, I'm not going to include it unless it's absolutely essential. If it's information that could be misinterpreted by other parties who have access to the records, I'm less inclined to include it. But I'm inclined to add more information, more detail. This won't surprise you. If there's a crisis, a critical incident, that seems to go without saying, I imagine. If I get new information that's clinically relevant, an email message, a text message, or SMS message, a telephone voicemail message that is clinically relevant, I better document it. Some people will literally copy and paste a text message, an email message, and put it in the record. Some people will paraphrase it, whatever makes the most sense to you. If it's a high-risk situation, there's a risk to the client of self-harm or harm to other parties, more documentation. If I'm anticipating litigation or a licensing board complaint, and I'm thinking like a chess player, several moves ahead, where I may need to defend my judgment in this litigation, this licensing board proceeding, I'm inclined to include more detail. If there's been an interruption, client hasn't shown up for appointments, excuse me, or there's been a technology failure if you're providing services remotely, right? I'm documenting that. The last bullet point on this slide, let me tell you about a case. It's a very sad case, which is what led me to add it to this slide. So I imagine many of you in your professional role conduct comprehensive assessments, biopsychosocial assessments. And this is my experience, and I suspect it's the experience many of you have had, where it's the first session, first meeting, you try to connect with the client, try to develop a little bit of therapeutic alliance, right? That's important. That's step number one. You're not going to just launch in to all the questions for assessment purposes. You're going to get there, but you don't do that in the first 2 minutes, right? You got to establish some therapeutic alliance here as best you can. And then you start with the usual intake questions. Now, I know in my experience, and I suspect this is true for some of you, that often there's not enough time in that first session to complete all of the questions. You get to as many as you can. You continue the next week. I was involved in a case in New York State where a very good social worker met for the first time with a client who had been hospitalized briefly in a psychiatric facility. He had a lot of conflict with family members, threatened a family member, threatened to harm himself. He was hospitalized. He gets released. He gets referred to the local mental health center. Social worker meets him for the first time, starts to go through all the assessment questions. There isn't enough time to complete them all. The plan was, this is on a Tuesday, to complete the rest of the items the following Tuesday, the next appointment. Well, that next appointment never happened because several days later on Friday, that client was in the apartment of his ex-wife, family conflict, with the child they had in common and the ex-wife's biological son from first marriage. They start to argue. It gets really ugly. And the client had a bag, pulled out a weapon, and in front of the mom, killed her biological son, the client's stepson. He's dead. And then he takes off. Long story short, surviving family members sued the social worker, alleging failure to assess risk, failure to prevent harm. And I'm the expert witness. I'm looking at the comprehensive intake form, biopsychosocial assessment, and I see all these blanks, right? Now, I know how this works. You know, you get to the first couple of pages, the first 12 items, whatever it is. And then there are a lot of blanks because she says, the social worker, she ran out of time, which I fully understand. And there were several items that were blank that had to do with risk assessment, right? Threats of self, to harm self, others, suicidal thought, all that stuff. And they're blank. And I knew what was going to happen here. I knew that plaintiff's counsel, the lawyer, was going to allege failure to assess properly, look at the blanks. So I asked the social worker, tell me about the blanks. And she said, I simply ran out of time. And I said, do you have a note in your record that says, began conducting the biopsychosocial assessment, reached item 12, I'm making up the number, and insufficient time to complete, will complete at the next session. There was no note. There is no note in the chart acknowledging that. Now, I absolutely believe that social worker. I have no reason not to believe her. I know this happens. But the lawyer for the plaintiffs will drive a truck through that hole. Will drive a truck through that hole. Social worker, you say you ran out of time. Show me the note that says you ran out of time, as opposed to you neglected to ask those questions. That's what happens. So if there's an unusual circumstance, insufficient time, I say, please document what happened in case there's a problem, like the next appointment never happens. Documentation tip number 2. I imagine you've all heard of the phrase defamation of character. I don't know if you're familiar with the kind of legal definition of it. My advice, tip number 2, is to carefully review the language you use to document. Be careful to avoid defamation. So what's defamation? Defamation occurs in 2 ways. It can occur as a result of what you say, that's called slander, or it can occur as a result of what you write or type, that's called libel, slander versus libel. For our discussion today, we're mostly concerned about libel because we're talking about documentation. So, lawyers typically say that defamation occurs when 3 things happen. First, you say, for today's discussion, you write something that's not true about a client. Second, you knew that what you wrote was untrue, or, this is a big or, you should have known that it was untrue. And third, the party you wrote or talked about was harmed. Those are the 3 elements of defamation typically. Again, if it comes out of your mouth at a meeting, that's slander. If it comes in the form of documentation, today's topic, that's what libel is. So, if you say something about a client's addiction, if you say something about a client's clinical depression, important to document what led you to that conclusion, and be sure you have evidence to back it up. Because, hypothetically, if your records get subpoenaed, the client is involved in a child custody dispute, what you said about the client's profound clinical depression, the client says is not true and challenges that clinical impression, which Wendy asked about earlier. If you don't have sufficient evidence in there to demonstrate that it's true, then you could be accused of defamation because what you said allegedly was not true. You can't demonstrate that it was true. And the client might argue that your comments about the clinical depression, the addiction, or whatever was used against the client. That's the 3rd element there with regard to the child custody dispute. Number 3, errors. Anybody can make a documentation error. I've made errors. Anybody can make a mistake. If it's in paper records, and I see from the poll results, right, that some of you are still using paper records, fine. Okay, that's a choice. What I say is be sure you handle the documentation errors really carefully. I'm guessing all of you have gotten this training, but just in case, paper records, don't use whiteout. Whiteout, as lawyers say, is not your friend. Whiteout, not your friend. By the way, I have that in quotation marks because that's not how the commercial product's name is spelled. It's not WHITE, it's WITE. They like whited out the H, ha ha ha. Probably for trademark protection, I'm guessing. Paper records, line through it, error, initials, date. And then you correct it, right? Be transparent. Forget the whiteout because it might suggest you're trying to hide something. If you have electronic records, as a large number of you have, I say if you cannot go back into that note and correct it because it might be locked, my advice is write a new note with today's date. Let's suppose you entered a note yesterday, there was an error, somebody's name, the date, you neglected to document that you consulted with Dr. Smith, a psychiatrist, whatever, and you realize it today or next week, then I'd write a new note. I would be transparent the current date, and then it would say something like, with respect to the note dated March 6th, this is supplemental information, or this writer wants to correct a statement in that note, and you simply say it. You say what happened. If it's a mistake, here's the correct information, or here's the supplemental information. That might not be an error. It might be an omission. It could be either one. So if it's an error, you correct it. If it's an omission, you supplement. And you're simply transparent about that. In my experience, usually that's not going to be a huge problem. It's usually not going to be a huge problem because courts, lawyers recognize it. All of us make mistakes. The point is to be transparent. Number 4, abbreviations make me nervous. Now, some of you may work in settings in Canada where the employer has an approved list of abbreviations. If there's an approved list and you stick to the approved list, then I think you're okay. But if there's no approved list, which I think is more common, I would avoid abbreviations because so many of them can be misinterpreted. SA, is that substance abuse or is it sexual assault? Right? DD, is that developmental disability or dual diagnosis, or what we now usually call co-occurring issues, but once upon a time, dual diagnosis. Okay, and BPD, is that borderline personality disorder or bipolar disorder? And abbreviations have gotten some social workers into some hot water because they couldn't clarify what they meant. Amphibole. Okay, so that's abbreviations. Number 5. This goes back to the point I made earlier when Wendy asked the question about recording clinical impressions. So I recommend avoiding broad characterizations. I try to stay away from language like poor outcome, good result, moderate compliance, drunk, aggressive, combative. I understand there may be times when we need to use that language. It may be necessary. And if so, there are those 3 words that I recommend at the end of that text there. As evidenced by, as evidenced by, as evidenced by. Put whatever you need to put in there to support your conclusion. Again, other people may disagree with your impressions, your conclusion, but if you include the rationale, you are likely to be able to defend any accusation that you were negligent. Number 6. Of course, in social work, crises occur. I mean, it's a given. It happens, right? And I understand that in a crisis, you may have to document in more detail. I even said that in an earlier slide. But I would also be careful not to over-document, in a crisis. You know, as Shakespeare said, sometimes the individual protests too much, right? Protests too much. Like, why did you include so much detail? It can come across as defensive. So more detail, yes. Too much detail, no. Got to thread that needle. Number 7, document as soon as possible, right? Because, you know, our memories fade. We get client A confused with client F if we've seen lots of clients during the day. So, you know, those of you who have employers, I recognize some of you are in private practice, but if you have employers, I would say be sure you comply with your employer's documentation guidelines. You know, critical incidents must be documented within X number of hours. If there's a change in client's needs within X number of days, and so forth and so on. And as I've said multiple times today, proofreading, editing, be careful if there are blanks. You know, account for the blanks, acknowledge the blanks. If you're using paper records and pens, legibility. I know this stuff seems kind of mundane and obvious, but I have them here on this slide because I've seen problems with social workers' notes that were not entered in a timely fashion, and it was used against them. That were not edited carefully, and that was used against them. Where there were blanks that were not explained or acknowledged, and that was used against them, like in that New York State case. Where there were legibility problems, and that was used against them. In that case in the state of Maine, you may recall that I had a screenshot of the state of Maine licensing board. And in the case in Maine where I testified as an expert witness, this is the case where the clinician, the social worker, was working with the adolescent client who was kind of missing in action, and they have extensive dialogue on Facebook that the kid's father reads. It's that case. And I told you that part of what I had to review in that case included the social worker's handwritten notes. He didn't type anything. He wrote his notes, sometimes on the back of scrap paper with, NCAA basketball brackets on the other side, literally. Not a good look. I read every one of those handwritten notes. That's my job. I could not understand a number of his statements. They're there. I see them. I didn't have the foggiest clue as to what they said because to me, they were not legible. Lawyers couldn't understand them. Hearing officer couldn't understand them. Legibility is a problem. And, I always think about those instances where a social worker who provides clinical services has a healthcare emergency, has to leave town for family reasons, and a colleague has to take over, right? That happens. It's life. Well, we have an ethical duty, in my opinion, to anticipate that possibility and to be sure that our notes are accessible by the colleague who's covering for us. If it's an electronic record, they can log in and get access to those records if necessary. Especially important if you're managing like suicidal ideation. And if the notes are handwritten, that the covering clinician, if necessary, has access to those notes. Well, if they're handwritten and they're not legible, that's a huge problem. Imagine a case where a social worker is covering for a colleague, goes into the record, there are handwritten notes that the covering social worker doesn't understand, and the illegible handwritten notes make references to suicidal ideation. That's a huge problem. Number 8, confidentiality. So all of us know that we are duty bound to explain to clients exceptions to their confidentiality. The various ways, and we know there are various ways in which what they share with us is not confidential: threat to self, threat to others, mandatory reporting, suspected abuse or neglect of a child, older adult, person with a disability, records that are subpoenaed and a judge orders disclosure, notes shared with a supervisor, whatever. I'm not going to rattle off dozens of ways in which clients' confidentiality can be breached by ethical standard and by law. We're obligated to explain all of that. Same thing with boundary issues. I'm going to guess that some of the individuals who are attending here today live and work in relatively small rural communities in your province. Not all Canadian social workers work in Montreal or Toronto or what have you. Many of them, and I've met many of them, work in relatively small and rural communities. And it's not a question of if there are boundary issues, it's when. Not if, but when. When that Canadian social worker bumps into the client at the supermarket, the food store, because there's only one, or where the social worker's child, who's 9 years old, and the client's child, who's 9 years old, are classmates in the 1/3 grade in this rural provincial community, and they're best buddies. There's a boundary issue there. So we know these things happen. And I would say ethically, Canadian social workers who live and work in relatively small communities should discuss with their clients how the social worker handles potential boundary and dual relationship challenges that arise. My point is, when we have these discussions about confidentiality exceptions, how we manage boundary and dual relationship challenges, we ought to document that we had the discussion. Because some lawyer might assert later that you should have had the discussion because the client says, I don't remember that. And you say, Oh, I did. I do that routinely. And the lawyer says, show me in your notes where it says you discuss confidentiality exceptions. You discussed how you handle boundary and dual relationship issues in the small rural community. Show me. If it's not written, it didn't happen. That's what the lawyer argues, even if it's not true that it didn't happen. If you have policies related to record storage and retention, access by third parties, please document that. Social media policies. When many of us started our careers, myself included, there was no such thing as a social media policy because there was no such thing as an online social network like Facebook or LinkedIn or Instagram or Twitter, now called X, and all the rest of it. But we now know that this technology exists, that social workers exercise their judgment about things like whether to conduct an online search for information about clients without the client's knowledge or consent. We know that social workers sometimes exchange text or SMS messages with clients. We know that social workers sometimes post things on X, formerly called Twitter, or TikTok, or what have you. And it is really, really important to have what I call a social media policy, to explain to clients how we conduct ourselves on the internet with this technology, explain it to them, and document in the chart that we've explained it. Number 9. I know this may sound a little silly and ridiculous, but I'm telling you because I've seen problems. Number 9, don't document interventions before they occur. How in heaven's name could that happen? You've seen a client for a year and a half, almost weekly, with some exceptions. The conversations tend to be pretty repetitive, and you have a few extra minutes before the session, and you document it to save yourself some time. And then it turns out the client has an emergency, a crisis, doesn't show up. You just documented something before it occurred. If it's an electronic note, it's locked. The optics are horrible. Number 10, I mentioned this earlier. Again, forgive me for sounding like a teacher of English, which I'm not, but the grammar issue, the punctuation issue, syntax issues. Lawyers love to find problems with our grammar, our punctuation, our spelling, and they love pointing it out if they are on the opposite side of the case, adversarial or opposing counsel, to undermine our credibility. Not nice, but I've seen it happen. Number 11. Yeah. If your records are subpoenaed, please. I mean, it's understandable. You'd review your records because maybe it's been a while since you saw that client. You got the subpoena, you review the records, and maybe you're thinking, uh-oh, I wish I hadn't said that. I wish I had worded it this way. I wish I had worded it that way. I wish I had included this. Maybe as a result of today's discussion. Well, don't alter or tamper with the record after you receive a subpoena. That's a problem. Lawyers have this lovely word they use called spoliation, not spoilation, spoliation. spoliation, and that can include altering a record that's been subpoenaed to try to cover up something, right? To make it look like we did provide that service, we did ask these questions. Be careful, please. Number 12, if there are staffing problems. So those of you not in private or independent practice, there's the potential for staffing problems. People who staff who don't show up at times, or they don't follow instructions with regard to the care of a client. If it's a staffing problem, I recommend not documenting that in the client's record. I think that's a personnel issue. It ought to be documented separately. It ought to be in a segregated location, is my opinion. It's not part of a client's record. Similarly, we know that in some social work settings, there can be disagreements among staff. We actually have a term for that. We call it jousting, like knights on horses with the in competition, jousting with lances. If there's disagreement among staff, which happens, one of you says, "I think we need to hospitalize this client. Here are all my reasons why," and you have a colleague who says, "I don't think so. Here are the reasons why." One colleague says, "I really think we need to tell the parents what the kid's disclosing in counseling because this kid is at risk. I think the parents need to know, even though the kid doesn't want us to." And a colleague says, "I'm not sure we're there yet. I don't agree." Okay, disagreement, jousting. I would not document the disagreement, the jousting, in the client's record. That can be a disaster. It may need to be documented in an administrative record, in a supervision record, but I would not put it in the client's record. I've seen that mistake. Number 14, spell check. So those of you using electronic records, a number of the platforms have spell check as an option. I would not be overly dependent on spell check, right? You still have to proofread carefully. This poem on this slide, if you run it through spell check, it will not pick up one single error. Not one single error. Not one, because every word is spelled correctly. But if you read that poem, it makes no sense. Candidate for a Pulitzer Prize, like Pulitzer, Pulitzer Prize. I have a spelling checker. It came with my PC. It plainly marks for, F-O-U-R, not F-O-R. My review, R-E-V-U-E, as opposed to R-E-V-I-E-W, and on and on and on. Every word is spelled correctly, and it makes no sense. Spell check would not pick up a problem. Number 15. This sort of goes back to my earlier point about always include those 3 words or something like those 3 words. If you share a clinical impression as evidenced by, similarly, I say, document what you know you can back up with evidence, as opposed to what you think that you have not backed up with evidence. Document what you know, not what you think. Subpoenas. There's an awful lot of confusion, I find, with regard to the difference between a subpoena and a court order. That was one of the poll questions. As I said, A, I'm not Canadian. B, I'm not a lawyer in Canada, so I can't give you legal advice about the law in Canada. But I will tell you what I believe to be true in Canada as well as in the US. A subpoena is an order to respond to a request for disclosure of information. It can come from our head, what we know in our head. That's called a subpoena ad testificandum. It's Latin. Or it can come from our documents, our notes, our records, right? And that's called a subpoena ducis tecum. Latin, D-U-C-E-S, new word T-E-C-U-M. Here's the way it works. Even though the subpoena typically includes very strong language along the lines of, you are commanded to appear and to bring with you the following documents, including but not limited to clinical records, progress notes, electronically stored information, yada, yada, yada. I've encountered cases where social workers misinterpret what a subpoena is. A subpoena is an order to respond to the request. The ethics guidelines in social work that I follow, which I help to craft, say if the client does not consent to the disclosure, if the client does not consent to the disclosure, we are obligated to challenge the subpoena. We're obligated to challenge the subpoena by filing what lawyers call a motion to quash, Q-U-A-S-H, not squash. Squash is a vegetable, or what you might do to a bug that's annoying you. I'm not condoning that, but people do that. A motion to quash, or a motion for what's called a protective order. We go to court, usually with the help of a lawyer, and argue that there are grounds to withhold those records to protect the client's privacy and so forth. A judge then has the authority to review the records in camera, meaning it's also Latin in camera, in chambers, to decide whether there are compelling grounds under Canadian law to compel disclosure in the interest of justice, even though it might violate the client's privacy. This is particularly relevant to debate about what's called privileged information or privileged communication. What's that? Not the same as confidentiality. My opinion is privileged information, privileged communication pertains to social workers' duty to protect confidential information during legal proceedings. Let me say that again. In my opinion, social workers have a duty to protect clients' confidential information during legal proceedings, divorce proceedings, child custody disputes, criminal court proceedings, what have you, to the extent permitted by law pertaining to privileged communication. So let me see if I can pull this up for you very quickly. I'm going to try to find you a website. Okay. So I hope, Annette and Wendy, you see on the screen motion to quash or modify a subpoena checklist. All right?
Yeah. Yep.
Thank you. Thank you. I just want to point out for fun, that's the Canadian flag. See where my cursor is? This is Canadian. This is not US. Motion to quash or modify a subpoena. A checklist of procedural steps and issues for counsel to consider when filing a motion to quash or modify in response to a subpoena in a federal civil lawsuit. I'm going to speculate that this also applies to lawsuits at the provincial level, but that's my guess, right? And okay, and then this is just a website that I guess you have to have a subscription to log in. So this concept appears to apply to Canadian law as well. Okay, motion to quash. All right. Number 17. Okay. Personal notes. And I invite Annette and Wendy to weigh in on this if they so wish. I know a lot of social workers who keep informal, personal, or what we call shadow notes. And they're meeting with a client, they have a pad of paper or a laptop or something, and they kind of, write some informal notes to keep track of what's going on in a session, in a meeting. We call this a memory jog. In the US, lawyers are really smart about this. When they subpoena social workers' records, documents, clinical notes, progress notes, and all that, they typically put on the subpoena, again called a subpoena ducis tecum, and any informal, personal, or shadow notes pertaining to this client. And sometimes social workers have them. They've not shred them, they have them. Well, they can't destroy those. That's spoliation. And sometimes those informal notes contain details that the social worker would prefer not to share with the court, with opposing counsel. So, my opinion, any social worker who keeps informal notes, personal notes, shadow notes, if they're permitted to do that. Some employers do not permit that. They don't want two sets of notes floating around, too risky. But if it's permitted in the setting in which you work, I would write every informal, personal, or shadow note as if someday it may be subpoenaed and as if someday a judge will order disclosure of those informal notes. Now, you're allowed to shred informal, personal, or shadow notes, but be prepared in a deposition or a trial under oath for some lawyer to ask you whether you've ever kept or recorded any personal, informal, or shadow notes. Have you ever recorded any informal, personal, or shadow notes pertaining to this matter? And the answer is yes. And the lawyer says, well, you've been subpoenaed. Did you bring them? No, I did not. Why did you not bring them? I shred them. Aha. When did you shred them? Did you shred them before you got the subpoena or after you got the subpoena? So you know where I'm headed with this. If you admit that you shredded them, which by the way, you are permitted to do, typically, be prepared to have to explain that. And one way to explain it, if it's true, is to say, well, during a meeting with a client, I often keep informal notes, and then I write up a more formal note for the record, and then I shred my informal notes. And here's the language I like, assuming it's true. That is my usual and customary practice. That is my usual and customary practice. I didn't shred them in this case because of this legal matter. This is what I do in every case. And in my experience, that's okay. So before I move on, Wendy or Annette, anything you want to say about Canadian law, personal notes, protection of personal notes, to the extent you're familiar with that?
So in terms of the organization that I work with, NL Health Services, when it comes to JAT notes, we have an actual clinical documentation policy, and it references exactly as you've said. So we indicate that, yes, we are aware folks use JAT notes, perhaps in certain situations, and that's to guide the profession in the completion of the documentation.
Mm-hmm.
And they're not, it's stated clearly, language around it's not to replace formal documentation, and that they are to be destroyed by shredding once formal documentation is complete. There's also a caveat in the doc policy, which I'll try and quote if I can recall it. It's around narrative notation is kept and added to the client file. So it allows for, if there's something that is felt cannot be captured some way in an electronic note, because we do have various systems in NL Health Services. So if there isn't a way to scan something in, there's a way for something that might not be considered a JOT note to be included. But our expected practice in the organization is that if you do use JOT note to complete client documentation, then they are destroyed once that formal documentation is done.
Great. And if someone doesn't comply with that and retains those informal notes, be prepared. They can be subpoenaed. Annette, did you want to add anything?
Yeah, sure. We also have on our website a explanatory document. So we have our main standards of practice and an explanatory document, and just around, that piece around caution around using, JOT notes and how JOT notes may be used, because it, does become part of the record if someone requests their information. So similar to what Wendy was saying in terms of people who are, using those because they're in a session, but once the formal note is written, and they should have everything in that note that's clinically relevant, then there's no need for that JOT note, right?
Very good. Okay, and I recognize we do need to take another 15-minute break soon, so I'm mindful of that. Let me just get through a few more of these, please. Number 18, I imagine a number of you work with couples and families. You provide services to groups, perhaps. I would be really careful. Think through. If you have one record for the family, and let's say you talk to one member of the family or the couple individually who's, complaining about another family member, and you document it in that chart, there's a pretty good chance the other family member has access to that chart. The family has access to the chart. The couple has access to the chart. And so there are instances where I recommend, and it's a bit of a nuisance, if you're going to be providing services to a couple or to family members, and everybody agrees you can talk to members of the couple or family individually, I would have a separate record for those individual conversations. I would document them separately, because then other family members don't have the right of access to those records, but not everybody thinks of that. And then they end up disclosing information, that they didn't want to disclose to a family member about a conversation with an individual in a couple or a family. So I would be really careful about that. Number 19, be familiar with key Canadian, national, and provincial laws related to documentation, key Canadian, national, and provincial social work standards and guidelines. And I list major ones there. We asked about those in the poll questions. The NLCSW website has links to a lot of this. So that's my list. And Wendy or Annette, is there anything else that should be on that list that I don't have there, do you think?
No, I think you've covered everything there. Looks great.
Okay, great. Okay. Number 20, I'll do this quickly because I know we need to take a break. Be familiar with provisions in pertinent federal, Canadian national and state, and it should say provincial laws, contracts, codes of ethics, agency policies related to things like who has access to your records, including minors, for example. Or if your client is a minor, as I said, if you move toward electronic records and portals, do the parents have access to the records? Guidelines regarding record retention. Wendy and Annette, feel free to weigh in on Canadian provincial law regarding record retention, record storage, to be sure this stuff is secure. I mentioned earlier problems I've encountered when social workers meet with collaterals and they didn't document that they said anything to the collateral about the collateral's rights or lack thereof, in contrast to a client's rights. They didn't use a collateral agreement. For those of you who work in integrated health, behavioral health settings, I'm a big fan of health, behavioral health settings, integrated settings. I would be really careful to ensure that only colleagues who have a need to know what's in your notes have access to your records. And that might not include a number of staff. There ought to be firewalls. There ought to be what we call break the glass protocols to limit who has access to your records in your workplace. I've been involved in too many cases where clerical staff, picture rural, a rural town in Newfoundland. And it turns out that the clerical person at the front desk is the first cousin of the client who is struggling with some behavioral health issues. Well, the cousin, who's the employee, should not have access to your clinical notes. And the question is, does that integrated health behavioral health setting have sufficient firewalls, so-called break the glass protocols, to limit who has access to your notes? Okay. Number 21, especially with regard to electronic records, I've mentioned all this, so I'll be really quick. Be careful about copy and paste, auto-population of certain fields to be sure that's not a problem, as it was in that Illinois case. Be sure that you have clear guidelines regarding who can access the records remotely, the logging off issue that I mentioned, and the firewall and break the glass protocol issue. So let me just stop here. Wendy and Annette, anything you want to say, any questions you want to raise before we take a break?
No, I don't have any questions or anything at this point. Wendy, I'm not sure if you have anything.
No, I think we can take some time, Annette, you and I during the break, and kind of collate any of the questions for themes for the next opportunity.
Great. All right. Well, I'm sorry you won't get a break because you're going to be taking a look at the Q&A. But it is, what time is it? It is, am I right about this? Is it 2:16 where you guys are?
Yes, it is. Yep.
All right. So it's 2:16 for you folks. We will come back in 15 minutes at 2:31. See you promptly at 2:31. Right. Let us resume. And I have a fair amount to cover in the remaining time. I realize we don't have a great deal of time left. But let me invite Wendy and Annette to share questions or comments, their own observations if they wish, before I begin to wrap all of this up.
Hi, Dr. Remer, it's Annette here. I think we can try to leave some of the questions to the end because some of the questions may be covered in the material that you're going to present. So we can then look at what's left at the end.
Okay.
So you continue on.
All right. So I do want to, before I continue, I do want to show you some examples of current technology that allows social workers to use artificial intelligence to generate their clinical notes. So these are not endorsements. I just want to be clear. These are not endorsements. I'm giving you examples. So here's one called Mentalic that a number of social workers are using to generate their notes using artificial intelligence. I've already made my comments about the potential benefits, but also the potential risks. That's one. Again, these are not endorsements. Here's one that's sponsored by AWS. That's Amazon Web Services. I imagine all of you are familiar with Amazon. Amazon has a product known as Health Scribe. Health Scribe also provides, in the States, HIPAA compliant. HIPAA is our Privacy Act in the States. And a lot of social workers are using this. Then another one is, and I hope these are showing up, Wendy and Annette. This one's called Blueprint, upper left-hand corner. The AI assistant for mental health therapists. Blueprint automates progress notes, drafts smart treatment plans, and surfaces actionable insights before, during, and after every client session. And then there is something called Upheal, secure AI progress notes that save you time, designed for therapists, psychiatrists, and coaches. Our AI-generated notes help you stay more present during sessions and save precious time. So you can appreciate why these tools have become so appealing to so many social workers. And I just want to reiterate, I've looked at a lot of notes generated by these and other AI platforms. And overall, I've been pretty impressed with the accuracy. And just to reiterate something I mentioned earlier, I'm also concerned about potential problems with errors and omissions, especially if and when social workers do not take the time to very carefully proofread the AI-generated note, edit it as necessary. Okay, so before the break, I shared with you 21 different tips. I'm going to show you a few slides really quickly because I'm imagining that all of you or most of you are familiar with standard documentation protocols. There's, and I, you know, some agencies prefer one as opposed to another. It's not like some of these are better than the other. I think they're all considered quite acceptable. The FACT approach, factual, accurate, complete, and timely protocol. Here's an example of what goes into a typical progress note. You can look at your leisure if you'd like. Many of you learned about SOAP notes, subjective, objective assessment, and plan. Some of you are familiar with, and I haven't the slightest idea how to pronounce that acronym. I'm not sure it's even pronounceable, SOAIG. The notes that include supplementary database information, observations, activities, impressions, and goals. I imagine some of you learned about the DAP note format, data assessment, and plan. I mentioned earlier, for those of you who are supervisors, I would be really, really careful to keep really good, accurate, complete supervision notes, summarizing what was discussed in supervision, feedback that you offered, and so forth. I mentioned the concepts of respondeat superior. That's in italics there because it's Latin, and vicarious liability. Then sometimes supervisors have to produce their notes to defend themselves if their allegations that supervision was not consistent with standards of care associated with supervision. I mentioned the importance of supervision agreements that lay out supervisors' responsibilities and supervisees' responsibilities, including bringing to the attention of supervisors any issues or concerns or questions they have around documentation or any of the other issues we've talked about today. This is all documentation-related advice. Oh, by the way, speaking of supervision, I should show you this. All right, I got a screen share here. Let me show you this super quickly to show you how things are changing in terms of documentation of supervision. So this, again, this is not an endorsement. This is for informational purposes. There's an artificial intelligence platform, LYSSN. Get it? Listen, haha. That's specifically designed for supervisors to document feedback they give to supervisees about the quality of supervisees' work, whether they are employees or social work students who are in internships or practica. And this is, as it says right here, an artificial intelligence training and QI quality improvement platform that uses gold standard evaluation tools to assess and improve fidelity to evidence-based practices. It is used for supervision purposes, right? To train and support staff, right there, to assess skill levels, to manage it. This is documentation, but it's generated by artificial intelligence, a platform that reviews a recording with client's permission of a clinical or a counseling or casework session. So I wanted to mention that. I bet when most of you went to social work school, these things didn't exist. Okay, let me move on. So a few examples. This is a note I don't like. Version A. Miss A's health is poor. She's not taking care of herself and isn't getting the services she needs. I don't care for this documentation, right? Doesn't explain in what ways Miss A's health is poor. There's no as evidenced by, no details about in what way she's not taking care of herself, not getting her needs met. I prefer, it takes more time, but I prefer a note that's a little bit more detailed. Ms. A reports health problems related to her heart and diabetes conditions. She said that she feels depressed and is not getting the help she feels she needs. I don't care for this note, example number 2. Mr. T clearly is ready to be discharged. There's no as evidenced by. It's just a statement. He's ready to be discharged from, let's say, the psychiatric facility or the substance use disorder treatment program. I prefer a note that looks like this. Mr. T meets the criteria for discharge. As evidenced by, there are those 3 words, his, number 1, satisfactory completion of treatment goals, number 2, consistent compliance with staff recommendations, and 3, active participation in the development of a discharge plan. It takes longer to write. I think it's a better note. Number 3, I don't care for this note. It was felt, passive voice. I don't like passive voice. Passive voice is different from active voice. It was felt, doesn't say by whom, that Ms. D was high risk for substance abuse relapse assessed for SA. Passive voice, what's the evidence of the high risk? Is SA substance abuse, or is there also a concern here about sexual assault? SA, abbreviation. I prefer. The treatment team reviewed and discussed Ms. D's clinical progress. The team concluded that Ms. D is at risk for substance abuse relapse based on her. That's kind of like as evidenced by. Same thing. Inconsistent attendance at treatment groups and infrequent participation during group discussions. This writer met with Mrs. D immediately after the meeting, 2:30 p.m., and assessed for substance abuse risk. I think that's a much better note. Number 4, I don't care for this note. Miss L was hostile and resistant during her enrollment in our program, as evidenced by what? It takes longer to write. On 3 occasions, Miss L did not respond to telephone messages to contact this program to schedule an appointment, date 1, date 2, date 3. This writer mailed Miss L a letter on date 4 asking her to call this office to schedule an appointment. On date 5, Miss L called me and screamed, quote, "You are never to call me again, never," unquote. By the way, I would never use quotation marks to paraphrase. Quotation marks are for literal quotes, not for paraphrase. This writer encouraged Miss L to make an appointment to discuss her concerns. Miss L responded by saying, quote, "I never want to see you again," unquote. This writer sent Miss L a follow-up letter on date 6, explaining her status in the program, inviting Miss L to schedule an appointment, and providing Miss L with a list of resources in the event she needs assistance. That's to avoid any allegation of improper termination of services or abandonment. All right, I want to leave time for Q&A. I'm not going to go over these, but if you are bored, you have nothing to do this Saturday night, you're looking for some entertainment, you may want to take a look at these slides, this one and the next one, which include some, I think, very funny, hysterical, yes, documentation can be funny at times, documentation tips, things to avoid. They're kind of humorous. This one and the next slide as well. Okay, so I mentioned at the beginning of our time together today that there's a wonderful book by a British journalist, Lynn Truss, Truss, entitled Eats, Shoots, and Leaves. Lynn Truss is a writer, and she writes about the importance of careful writing and documentation. You're thinking, oh my gosh, like a whole book on this stuff? And the book opens with this. A panda walks into a cafe. He orders a sandwich, eats it, then draws a gun and fires 2 shots in the air. Why? Asks the confused waiter as the panda makes towards the exit. The panda produces a badly punctuated wildlife manual and tosses it over his shoulder. I'm a panda, he says at the door. Look it up. The waiter turns to the relevant entry and sure enough finds an explanation. Panda, large black and white bear-like mammal native to China, eats, shoots, and leaves. So that comma after the word eats a sandwich, shoots a gun in the air, and walks out the door, right? But if you take out the comma, leave the words exactly as they are, all you do is take out the comma. Then what does it mean? He eats shoots, as in bamboo shoots, because that's what pandas do, and leaves that are on the tree. Eats shoots and leaves. That's really different. To use the word I mentioned earlier, amphibole. 1 comma renders the meaning completely different. And these are more examples of amphibole. Like, if you're not careful with punctuation, there can be a lot of misunderstanding. In the final slide, I have examples of literature that you might find helpful on documentation. Some written by me, some written by colleagues. My colleagues' work is terrific. You'll see the 3rd bullet point down. This is a book of mine that just came out like literally a week ago, entitled Artificial Intelligence in the Behavioral Health Professions, Ethical and Risk Management Issues, published by the National Association of Social Workers in the United States. I have a lot of stuff in here on documentation issues, issues I could not have imagined when I started my career. And I bet that's true for many of you. When I started my career, the cloud was the white fluffy thing in the sky, hanging over St. John's or Halifax, full stop. Not where we now store electronic records. When I started my career, a tweet was the sound a bird made. That was it. Not something associated with what until recently was called Twitter, now called X. And when I started my career, TikTok was the sound a clock made, full stop. Not a smartphone app that some social workers are using that produces evidence used in litigation cases. The world has changed. So I think I also have, excuse me. No, I guess that's it. Okay. So I do have a couple of final comments to make, but before I do that, in the remaining time, I'll hand it over to Wendy and to Annette, and we'll take some questions and your comments, including those that might differ from my points of view, which are absolutely fine.
Perfect. Thanks, Dr. Reamer. I'm just going to start with the question I think that Annette and I will address and then lead into a few of the others. There's been some questions around abbreviation and whether it's appropriate to use at the start of a clinical note and then abbreviate throughout. So Annette, I know the NLCSW has a bit of information on that you might want to reference.
Yes, and I'm going to try to share my screen to see if this works. So if you could let me know if you're seeing that. But this is a documentation matter. So this is a whole series that our ethics committee does on different tips around documentation. So in tip number 2, so back in February 2020, we did develop a practice resource on that, documentation matters. So it just goes through some, reflective questions in terms of, asking yourself if you're, with the whole topic of abbreviations, because it's important that the note be clear and not left open to any interpretations or misinterpretations. So, for example, some of the questions might include: is the abbreviation or acronym widely known? So, for example, HIV/AIDS. Would you need to spell that out every time, or is that a widely known acronym? Could the acronym be confusing? And as Dr. Reamer said, SA could mean sexual assault or substance abuse. So, thinking about some of those things. Has the full word been used previously, in the chart? Is it an abbreviation or an acronym that's approved for use by the organization or in the circle of care? And could the use of that acronym actually impact client care negatively, right? So those are just some of the reflective questions when you're thinking about, the use of acronyms in practice because of that impact that it could have on client care, because of the misinterpretations that acronym could create. So I just wanted to share that practice resource as one example of our Documentation Matters series.
Perfect. Thanks, Annette. So in follow-up to that, for recognizing that there's folks from different organizations attending, for NL Health Services as an example, our organizational policy, which the college would request that we kind of look at, we advise to avoid the use of abbreviations wherever possible, and we also have an approved list. So if we have to, there's an approved list, because of course we're in a medical sense, but we avoid against use of wherever possible. Okay, so Dr. Reamer, we themed some questions for you. One of the first ones is, how do we balance meeting documentation standards while with competing workload demands? An easy question.
Yeah. And shall I assume that means we're not given enough time to document? If we were to follow all these tips that I'm sharing, and perhaps the Documentation Matters tips to which Annette referred, if we take all of this stuff seriously, we'd be working 37-hour days. Is that the implication of that question?
Yes, I think summarized, it's caseload demands often don't allow for time to work wholesome.
Right. Yeah. All right. So let me look around here for my magic wand. I don't have a magic wand. I just look for, I don't have one. So, in a perfect world, not the one I live in, I suspect not the one you live in, our employers would provide us with adequate time to document consistent with standards of care. And we know that not all organizations do that. So what I typically recommend, and I realize this is not a quick fix, but I think this is our ethical duty consistent with language in our respective codes of ethics, Canadian and US. And that is, and I'll paraphrase, and this is almost the exact wording in the NASW Code of Ethics. If social workers believe that employing organizations' policies and protocols are not consistent with social work standards, I'll put in parentheses regarding proper documentation, social workers are obligated to share their concerns with employers, to acquaint employers with standards in the social work profession so that social workers can comply with them. In English, or French, I suppose, but in English, I'll just use English, going to people in a position of authority and saying something like, there is just, my caseload's too big. I don't have enough time. Can we talk about making some adjustments here? And I would document that conversation. It shows a good faith effort on your part to raise the concern. If the powers that be say, thank you very much for sharing your concerns, Wendy and Annette. Thank you so much. You can go back to your room now. Do what we tell you to do. If that's the message, you've at least documented that you've made a good faith effort. So let us suppose some documentation issues arise, and you're accused of not having documented in a timely fashion, sufficiently detailed, and all of that. And your response is, I don't have the time to do all this. Then you get to produce a note that says, I raised my concern. I shared social work standards. This is what I was told. And here's the phrase I typically use. You're only responsible for that over which you have control. You don't have control, perhaps, over how much time your employers allocate for documentation and all that. But you do have control over raising your concerns, speaking truth to power, if you will, and documenting that, making the good faith effort. And beyond that, I'm not sure there's a whole lot we can do other than to engage in constructive advocacy to try to get organizations to make constructive changes in this regard. That's not terribly helpful, I suspect, but that's the best I can do. And Wendy and Annette, I don't know if you want to add to that, but those are my thoughts.
Just a quick question to follow up on that. So, in terms of the impact on client care, can you elaborate on that piece around, documentation and if you're having issues, like for example, the high workload and those kinds of things, can you provide any perspective on that in terms of impact on clients?
So, as I said earlier, I mean, I think we would all agree our fundamental duty primarily is to clients. And also, we have a right to protect ourselves. So, if I'm working in a setting in your province where I'm concerned that organizational policies prevent me from adequately documenting my services in a timely fashion, I would summarize examples. I would take them to supervisors and administrators, and I would communicate this in a way that they may get their attention. And it goes like this. I'm really concerned. Let me give you a few examples of how the lack of adequate time to document could really harm our clients. For example, if we're referring them to other providers, we don't have sufficient detail in our notes, I'd go down that road. And then to get their attention, I would say, and by the way, I went to this webinar in March of 2025. There was some guy from Rhode Island who spoke. I don't remember his name, but some guy, and he talked about the legal exposure, the ways in which organizations like ours could be at risk. We can be sued. We can be held accountable if the organizations don't provide adequate time for thorough, comprehensive documentation. That, in my experience, tends to get administrators' attention. Blame it on me. Fine by me. Fine by me.
Okay, thank you. So we have two questions left, and I do want to leave time to kind of close out the session. Thoughts about directly quoting clients in notes. So you did reference this a little bit, but there were several questions around whether or not quoting a client and in what context would be recommended.
So I like putting literal quotes in when the literal quote supports my conclusion about clinical status, their mood, their risk level. I don't put it in gratuitously. I don't quote clients just because it's fun to quote clients. I'm very selective. I quote them if their words are compelling and need to know. Anything I put in the record, I put in there because I think I or somebody else who has access to the record needs to know what the client said in the client's words about life is not worth living, I'm feeling sometimes, or I feel like I could kill my ex, or whatever those compelling words are. I think they ought to be compelling, clinically relevant, and they ought to fall under need to know.
Okay, and super cognizant of time, but the final question was around client confidentiality. So there was reference, and I'll summarize, to a social worker being on a team, and then a client either at intake or by a different provider being given an explanation of confidentiality and informed consent. And the question is really whether we as social workers should be having that conversation at the start when we see the client directly ourselves.
My opinion, and I might adjust my answer if I knew more facts, but my general answer to that question is yes. We ought to be having that conversation. We ought to be documenting it at the front end, is my opinion.
Good, since that's what I answered.
Okay. Great minds think alike. Yeah.
So that sort of summarized. We didn't get to all of the questions that weren't particularly specific to the documentation content itself, but just know for folks in attendance that Annette and I have been kind of summarizing those, and we'll look at opportunities perhaps for the college and maybe through partnerships to be able to kind of respond to some of those questions. But I do want to take a minute, Dr. Reamer, to thank you for facilitating this excellent webinar today and sharing your knowledge, expertise, and your experience, in particular the examples I found most helpful. A lot of information pertaining to social work documentation was covered. We spent quite a bit of time together. As social workers, we're committed to providing high quality social work services, and as highlighted in the webinar, documentation and service delivery, of course, go hand in hand. So for housekeeping, for us as social workers, you can claim 5 required CPE credits for attending this webinar as part of the NLCSW policy. And as noted, the PDF should appear in the resource section, cognizant there was a little bit of a glitch. And also, as Annette and Dr. Reamer have mentioned, NLCSW has a wealth of information pertaining to social work documentation that you can access on the website. And I personally reference that often in my work with NL Health Services. So I encourage you to read through those practice resources and consider how they're applied to practice. And of course, those can also count as continuing education for self-directed learning under that category. And also another question that was in the chat is this session is recorded, so you can watch it, often refer back to it. You can also spread the word to your colleagues on that. So in closing, thank you, Dr. Reamer, for putting a spotlight on social work documentation today. It's been an absolute pleasure for you to join us in this in-depth webinar on the important topic. And we want to thank you for taking time from what I'm sure must be a busy schedule and meeting with social workers in Newfoundland and Labrador. I will remind folks that as you begin to sign off, there will be an evaluation form that will pop up on your screen. Please take the time to complete that because participation, I know the college does really review that for informing future sessions. And thanks again to everyone. Enjoy the rest of the day, and please enjoy Social Work Month and the other events that are scheduled.
And if I can take 30 seconds, because I think we have 30 seconds, I want to thank you, Wendy and Annette, for all the time you put in to help make this possible. So much goes on behind the curtain, and I hope the participants appreciate that. It truly has been an honor to join you in this international conversation. And I want to thank you for being social workers during Social Work Month, because it really, really, really matters. The world needs us. And as I said at the very beginning, I recognize people log into these things with varying degrees of enthusiasm. Whatever your reasons were for logging in today, I hope you're logging off feeling like you learned a lot, your brains were stretched in a good way. I thank you for your fine comments and questions. I want to thank Wendy and Annette for their wonderful collation of all the comments and questions and their insights. It's been a privilege. Be well, everybody.
And I just want to say, we referenced some of Dr. Reamer's books. I'm just going to show them here. The Social Work Ethics Audit, the Social Work Ethics Casebook, and Boundary Issues and Dual Relationships. You should have those on your desk. They're excellent, excellent resources. So Dr. Reamer, it was an absolute pleasure having you join us today and being able to collaborate with you on this very important topic. And in our resource section, in addition to the slides, we've had the links to our standards of practice, our links to our code of ethics that talks about the critical importance of documentation and why we have that professional responsibility, which you laid out right at the beginning of the session of why we need to be documenting and the importance of documentation. So I really appreciate, and it did not seem like 5 hours, your first slide when you said, I want to keep you awake. I was enthralled the whole time. So thank you so much.
Be well, everybody. Take care.
Thank you.